name, Lord. We are
All right.
May I please, Your Lordship? I beg to mention item number 8. Kindly pass over the matter for today.
Item number
8.
8.
The matter may be fixed on 21st of August, but the workout matter has been fixed on the 21st of August.
Why adjournment today?
My senior counsel B. Chaudhary is having some minor operation in her legs.
On the pair being made by Mr.
A. Banerjee.
Learned Counsel appearing on Learned Counsel for the petitioner. Recessal is the matter on 21st.
21st of
Okay.
Obliged.
May I please, Your Lordship? Is the listing of a matter, Your Lordship, in this week, Your Lordship?
When?
Any week this week, Your Lordship?
Take a date from him.
22nd.
May it please,
22nd. Obliged, Your Lordship.
May it please your lordship. Lordship, item number 36. It is in this matter we have already filed our affidavit in opposition. So lordship may kindly allow to bring it on record.
Okay. Okay.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 18, Lordship.
Yes.
The matter may be adjourned for a day, Lordship.
On the pair being made by Mr. P. Bordola, Learned Counsel for the appellant. Recessal is the matter. When?
After a week, Lordship.
After a week. Okay.
Obliged, Your Lordship.
I pray for listing of an IA, my lord, for substitution. Lord.
When?
Any day, tomorrow, day after tomorrow, any day. For subs-
Next week, 27th.
May I please, Your Lordship? Lordship, I beg to mention for listing of an IEA for correction in the cost title.
When?
Wednesday, Lordship, 21st. Much obliged.
May I please, Your Lordship? I beg to mention item number 19. This may be password for today and may be listed after a week. Item 19.
Why?
My senior Mr. L. Talukdar is out of station.
On the pair being made by Mr.
Yeah, I mean,
A. Ahmed, Learned Counsel for the Learned Counsel appearing on behalf of Mr. L. Talukdar, Learned Counsel for the appellant. Recessal is the matter
after the week.
after a week. Okay.
Obliged.
May I please, Your Lordship? I pay for listing a matter for orders.
When?
Which is last posted on 16th and 23rd.
On 28th. 28th August.
Obliged.
My lord, I pray for listing tomorrow, my lord. I filed today. Your CRP, my lord. Case was fixed. in the
Tomorrow
court.
possible? Tomorrow may not be possible. We have a large number of cases.
Motion, my lord, only thing that.
Day
my lord-
after tomorrow?
Yes, tomorrow is fixed, my lord, at Nagaon. That
No,
is why.
tomorrow possible. Okay, we'll try.
Right.
But at your risk, the matter may not reach tomorrow also.
May not be risked that.
Okay.
I will tell you.
Items from daily list, item number 1. Promotion bail application.
Who is?
Of Your Lordship.
Bobby, your name is reflected in the cause list. T. Thakuria. Who is T. Thakuria? Okay, at 2 p.m. 2 p.m. At 2 p.m.
Highly obliged.
Item 2, promotion.
May I please? This is transfer application order filed by wife. Husband instituted civil suit claiming 1 crore compensation. And already I am paying for transfer. from reside in Nagaon.
Another divorce case is pending between the parties at
3
Nagaon
cases
court.
are pending at. 3 cases.
Which one is earlier?
This is later. Those cases are pending. The trial is going on.
No. My pointed query is another divorce suit is pending between the same parties at Nagaon.
Nagaon. It is filed by me.
Yes. Which one is earlier?
Mine is again. He filed another divorce, that is also state. And now he has filed the present case, it is sought to be transferred. It is a case praying for 1 crore compensation
Under which provision?
under civil law.
Okay, heard Mr. Ayuddin, Learned Counsel for the
Your Lordship,
Uh,
page 28 is the.
petitioner. This petition under section 24 of the CPC is prepared by the applicant for transferring title Manisut number MS 03 of 2024. Pending before the Court of Learned Civil Judge Senior Division Hosai. Shankardev Nagar to the Court of Learned Civil Judge Senior Division Nagaon or to any other competent court of Nagaon district. Mr. Uddin, Learned Counsel for the applicant submits that. The Learned Counsel for the petitioner submits that. The petitioner is the wife of the opposite party respondent, stroke respondent. And she has been residing, and they are husband and wife, and she has been residing at Nagaon in her parental abode. Whereas the respondent is residing at Lanka under Hosai district. And that several other cases are also pending between them in the court at Nagaon. And therefore, Mr. Uddin contended that this Manisut number 03 of 2024 may be transferred from the Court of Learned Civil Judge Hosai to the Senior Division Hosai to the Civil Judge Senior Division Nagaon or to any other competent court of Nagaon district. Where is the petition and the documents placed on record? Let notice be issued returnable in 4 weeks. Step be taken by registered post with ADN also by usual process. Within a week from today. Lays the matter after 4 weeks. Until returnable date, Manisut number 03 of 2024 pending before the Court of Learned Civil Judge Senior Division, Hosai instance state.
Oblige.
And number 3,
No, no, this the matter earlier.
Yes, yes.
Now this matter has been transferred to commercial court civil judge number 3.
Civil Judge 3.
See, my lord, this may, civil judge 3 may be directed, my lord, to take up the matter and release the amount, my lord,
Civil Judge 3.
and to dispose of the matter within 6 months as per commercial court.
Yes, Mr. Nath.
But if the court has been allotted now, it has gone to the civil judge 3.
Hmm.
Then the application may be filed before the civil judge 3 because it is pending.
Already
The
application is there.
Civil judge, he will decide, he will take a call.
Because your lordship find, my lord, application is at page 14. That is there. It will go to civil judge number 3.
Yes.
And order was there, my lord, for necessary order, it was fixed on 7th. So he can pass an order on the basis of this case. Because entire record has come there. Page 14, my lord, that is the fix.
Lordship may indicate a time frame within a, Lordship may indicate a time frame for consideration of this. He will decide that.
Yes.
He will
Within,
consider the application.
within 2 weeks, my lord, it, whatever we pass, my lord.
2 weeks.
My lord,
Within 2 weeks.
within 2 weeks, my lord, it can be done within a day also, but I am praying for 2 weeks, my lord.
No, we are disposing of this petition.
Yes, this.
Directing the
Civil judge number 3, my lord.
to consider your application within 2 weeks.
But
First necessary
the
orders.
petitioner may have to file a fresh petition because with the honorable.
Not necessarily. This petition has not yet been disposed of.
Yes.
They are already, an order has been passed fixing on 6/11.
Hmm.
With the honorable court order, liberty will be given to them to.
That
approve
was the
fresh-
transfer order, my lord, not just national district judge has
I-
fixed
Mm.
order.
Anyway, we are disposing of this application.
yes.
The trial court shall consider the same within 2 weeks from today.
Lordship. Problem.
Well, civil charge number 3 may be mentioned. Madam.
Pardon?
Civil charge number 3 may be mentioned.
Yes, yes.
Item number 4.
Lordship.
My lord, the matter relates to refusal of additional evidence which was sought to be adduced before the learned appellate court against the respondents. Wherein we are the appellant thereof. So considering the said situation, there were 4 petitioners challenged the impugned order which is presently before your lordship under challenge. And out of the 4 petitioners, 1 petition has been allowed by this honorable court, which your lordship may kindly find page 72. Operative portion of the order, para
No,
3.
you have filed the petition under order 41, rule 27.
Yes.
So some conditions are there. But your petitioner failed to fulfill those conditions.
Yes.
So how can the learned
thereafter,
appellate
Madam,
court
we
can
have-
exercise the jurisdiction under the said provision of law?
And this aspect was already considered by this court under the light of the apex court order passed in Union of India versus Ibrahim Uddin, wherein the Honorable Supreme Court held that categorically observed that
You saw the order,
page 72, madam,
page?
72. Annexure 9. Last.
Yes.
May I read out, madam? Paragraph 3.
Mm.
In the backdrop of the above, this court finds it relevant to take note of the judgment of the Supreme Court in the case of Union of India versus Ibrahimuddin so-and-so reported in so-and-so, wherein the Supreme Court had categorically observed that the stage of taking an application under the order 41 rule 27 is at the time when the court takes up the said appeal for final disposal. Taking into account the said application under order 41 rule 27 has been rejected even prior to the appeal been taken up for hearing on merits. The impugned order dated 18/8/22 suffers from jurisdictional error and consequently the said impugned order dated 18/8/22 passed in Ms. J case number so and so stands set aside and quashed. The consequential effect of setting aside the said or impugned order is that the order dated 28/7/22 passed in Ms. J case number so case is also become redundant. So my lord, I pay similar relief because on the same day, 4 petitions were rejected and 4 are approached this court, and out of 4, 1 is already disposed of, others are pending. So under the light of this honorable court's order, this petition may be disposed of and let them try before the appellate court the remaining situation. It was passed on 9/4, my lord. Same order, impugned order, 18/8/22.
Against the same impugned order.
Same opposite party, Vishwanath Jajuria. I have let me compare it at page 71, madam. One petitioner is Sujya Kolita, opposite party is same. Sujya Vishwanath Jajuria, same address, same issue.
Okay, we'll see. We'll pass the order.
Item 5.
Public.
Lordship, my senior is in league in court number 4. Kindly pass over the matter of time.
Okay, after some time.
Item 6.
My lord, in this case, we have filed a petition to implead myself in the particular case of that is 269 of 2013. My lord, in this case, my lord, we have a property in Lamb Road, in which the permissible area
So how the impugned order suffers from any irregularity or
My
impropriety?
lord, the contract in that particular contract, there are two.
No, your petitioner is not a party to the suit pending before the trial court.
But then we have interest on the suite property. We have interest in the suite property itself, on which the contract is based. There are two, they have filed counter claim also, but we have interest in the suite property, my lord. The situation is like that, and the first floor, the permissible area is 13 square feet. And we have already purchased 1287 square feet. Now, if the builder sells to another 1120 square feet to someone else, then, on the plaintiff, then, or as per he has counterclaim to another party, he has made two agreements with two different persons actually. With regard to the particular that 1120 square feet, then it will definitely come into it will affect my position. So that is the problem.
So the suit was for a specific performance of contract.
Specific performance of the contract, but the contract.
It,
whatever
it was between plaintiff and the defendant number one. You were not party to the suit.
Yes, we understand, my lord.
So
but then
how the impugn order suffers from
the
irregularity?
suite property, the suite property, the property itself
Hmm.
is within my domain. That is the problem. I mean, the first floor, of which there are two parts. One part is, that is 1287 square feet, and another part is 1120 square feet. My lord, but the permissible area to build in that particular floor is only 1413 square feet. If 1287 square feet is sold to me, then they are left only 143 square feet for the other person, dependent. But instead of that, if the plaintiff, if the builder sells another 1200 or 1100 square feet to that other plaintiff of the particular 269, then I will definitely, it will be from my part. That is the problem. Because the built up area is fixed.
So that is your apprehension only, as observed by the trial court.
It's not apprehension, my
Hmm.
lord. Actually, if they sell, if either of the, even in this case, my lord, they have filed a counterclaim also.
If there is any cause of action, you file an
Yes,
independent
I
suit.
did. I did.
Hmm?
In the memo of the miscase, madam, annex of 5.
How can you implement yourselves in the suit for specific performance of contract?
Pardon me? Sir? My lord, according to me, the contract is based on wrong footage. My lord, the value or the amount of land or the contract on which the product on which the contract is made, my lord, the land on over which the contract is made, that is from my share of the land, my share of the property. Because they are selling 1120 square. And permissible area to construct in that particular building is only 1413 square feet. My lord, you may say page number 17A. That is marked as Annexure X. My lord, in page number 17A. the
Page
G-
number?
Page number 17A. Annexure X, it was marked as Annexure X. My lord, there it can be seen like this is the permission of GMDA permission for building. It's very specifically written that in first floor, my lord, that is the suite premise, that is only 113.13 square meter can be sold. That translated into 14.13 square feet. And since we are already purchasing 1287 square feet, that means to sell, they can have only 114 square feet or so. In that situation, my lord, had they made the contract on 114 square feet, then we don't have any problem. Then I would have been immune. But since they are making a claim of 112 to 1120 square feet, there we have problem.
So even if we admit your petition, what kind of relief you will get in this title suit?
Yes, my lord.
Because
The contract value has to be changed by the defendant.
pardon?
The contract value has to be changed, my lord. The amount of land which they are selling has to be different. Because I have already purchased 1287 square feet and there remained only 114 square feet for them to sell. For the builder to sell. So 114 square feet he can sell, but he cannot sell 1,000.
As observed by the trial court, it is only your apprehension. If your right is violated, you go for
Definitely it is my-
independent suit. You file an independent suit.
I thought at this moment, my property is safe, so I do not have any issues. But the moment they will, the moment
No, that's why the
just
trial court
pass.
has rightly observed that it is your apprehension only. Hmm?
But the contract, my lord, since they are already including the 100 and
If anything in future happened, you can approach the court by filing appropriate petition or suit, whatever be.
my lord, already it is been affected because they are already entering it there because they are filing their contract is registered. Already they are using my property, my part of the land into their condition, into their contract.
No, in this specific performance of contract suit,
Yes, my lord. That
you
they have
cannot
got
you cannot
registered.
be implemented.
They have got they have got two specific this thing. They have already registered deeds on that, so they cannot make registered deeds as such on my property, on my land.
Okay, we are refixing it today or okay, when sorted.
Noted the lordship on 28.
28. Heard Ms. S. Goswami, learned counsel for the petitioner. Order dated 17/1/2024, passed by the learned civil judge senior division number 3, Kamrup M in Guwahati. In Mijay case number 777 of 2023, in title suit number 269 of 2013, is challenged in this petition by the petitioner. Namely, Sri Dilip Kumar Barua. Peruse the petition and the documents enclosed with the same. List the matter on Friday. Friday is holiday.
Coming Friday is holiday, 23rd is holiday. 28 Tuesday,
Sorted
27,
27.
27 Tuesday.
My
28,
lord, 27, I don't have some problem. I have got a.
Sorted
Then 22nd,
22nd. Okay, 22nd.
Item 7.
Meet Mr. Lordship, my lord. My lord, here the respondents, my lord, they have filed one suit, my lord. Page, Lordship, Annexure 3, page 27. Suit is for page 20, declaration, confirmation of possession and permanent injunction. Page 28, my lord. A schedule of the land, my lord, is 2 katha 10 lesson. Schedule is at page 37. my lord. And along with this suit, my lord, they also filed miscase page 39 for injunction under Order 39 Rule 1 and 2, Section 151. Now,
Page
this
number?
Page number 39. Injunction petition they filed for restraining this petitioner for entering into the suit land. Now, my lord, this suit as well as the miscase is fixed on, my lord, page 51 on 22/8/2024. Because they have also filed one petition on 25/7 that they want to implement the deputy commissioner as a party. And along with this, my lord, for consideration of miscase for injunction, this is fixed for objection and opposite party hearing on petition 22/8. Now, my lord, in the meantime, while this suit as well as the my lord, injunction petition fixed on 22/8, they have filed one petition, page 52. Under section 151, my lord, seeking injunction, under inherent jurisdiction of the honorable court. Now, the learned court below has passed order, page 58, impugn order, my lord.
50?
58, my lord. Annexure 9. Second para, it is stated, my lord. The suit as well as injunction is fixed on, my lord, 22/8. Now, my question challenging this order is that, my lord, while there is a specific provision for granting injunction and that is pending for concession is on fixed on a particular date, and in between on a non-scheduled date, they have filed this petition on 2/8 without serving us any copy. An order has been passed on 5/8/2028 on a non-scheduled date without hearing us, my lord. So, while there is a specific provision, my lord, the court below could not have exercised power under 151 for granting injunction. If this is the injunction they pass, what the injunction order they will consider in the, my lord, main injunction petition under Order 39. My lord, one judgment, just one paragraph, my lord. While there is specific provision under CPC, then 151 may not be exercised. This is the judgment, my lord. It is honorable earlier Chief Justice N.V. Raman, my lord. Page, my lord, paragraph 28. That otherwise, page paragraph 26, 27, and 28. My lord, may kindly have a look at paragraph 28 at page 7 down below pagination, my lord. Section 151 CPC can only be applicable if there is no alternative remedy available in accordance with the existing provision of law. Such inherent power cannot override statutory provision or create remedies which are not contemplated under the code. Section 151 cannot be invoked as an alternative filing test to appeal, revision, or review. A party can find solace 151 to LS, rectify historic wrongs and bypass procedural safeguards inbuilt in CPC. So, cannot the party to bypass a party cannot find solace under it is a case that on a off date, non-scheduled date, they have moved this application without serving copy. They heard this matter expertly. So, and while this 139 application is pending to be considered, this order could not have been passed behind our back, my lord. Therefore, I pray for my lord, for staying this order, my lord. And in fact, the petitioner hearing as my lord, plaintiff page 14, my lord. Already there was a suit for demarcation of the same suit land. This judgment put under challenge by the respondents herein, and there is already a stay order, page 26, my lord, in the appeal. So accessing power under 115 does not arise. And even if they have, the learned court wanted to pass, it could have been passed hearing us, serving us copy. This is a non-scheduled day because suit, my lord, their suit as well as injunction petition was fixed on 22/8, my lord. They have filed it a non-scheduled day on 2/5 and my lord, order has been passed on 5/8. It's absolutely, my lord, behind our back, my lord, without granting any opportunity, my lord. There is no such dying urgency, my lord, to pass such order, my lord. Let them place the injunction petition
So,
on 22.
in the
Yes,
order dated 5/8/2024,
yes.
in this fourth paragraph, it has been reflected.
Being so, finding no other option, in the hand compelled to address the grievance of the
No,
petition.
this other one,
My lord,
that being
being
the situation in hand.
hand, immediate concern shows the petitioner in view their petition number showing, so this is the petition, my lord.
Mm.
Compel this court to take matter up for hearing, thereby direct the opposite party to present their stay, if any, from their point of view, so as to enable this. My lord, I do not know, because kindly see, my lord, once again, that order suit, my lord, the page 51. The earlier date was 25/7. By order, page 51, my lord, the suit and the injunction was fixed by order dated 25/7/24 on 22/8, my lord. And this development happened in between, my lord. This court could not have passed this order, my lord. And while their petition is pending for consideration and injunction, my lord. Why the court has passed this order, my lord? And they can praise very well the injunction petition on 22/8, my lord.
So we can set aside the order, remand the matter
Yes,
to the
yes.
trial court.
Yes, yes. For placing the parties for injunction petition pending.
Or Mr. BK Das, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India is directed against the order dated 5/8/2024 passed by the learned Civil Judge Senior Division Dibrugarh in the petition number 5331/2024 filed in Mizze case number 184 in TS number 91 of 2024. Mr. Das, learned counsel for the petitioner, submits that the respondent number 1 to 4 as plaintiff have instituted a suit being title suit number 91 of 2024 against the petitioner and respondent number 5 for declaration of right title and confirmation of possession and permanent injunction over the suit land. And also file separate Mizze case number 184/24 praying for granting interim injunction restraining the petitioner and his agent from entering into the suit land. Thereafter, the learned Civil Judge Senior Division Dibrugarh has fixed the Mizze case number 184 of 2024 for injunction, fixing on for hearing on the point of injunction on 22/8/2024 for filing written objection in hearing. Thereafter, the respondent number 1 to 4 file another petition bearing number 5331 of 2024 under section 151 of the CPC. In Ms. J case number 184 of 2024, on a non-scheduled date before the learned Civil Judge Senior Division Dibrugarh for granting temporary injunction, which was taken up by the learned Civil Judge on 5/8/2024 without serving a copy to the petitioner. And intimating that the petition will be taken up for hearing on 5/8/2024. Thereafter, by order dated 5/8/2024, the learned Civil Judge Senior Division has granted injunction illegally and arbitrarily on a non-scheduled date behind the back of the petitioner. And therefore, Mr. Das submits that the impugned order may be set aside and the matter be remanded to the learned trial court, as the matter has already been fixed on 22/8/2024
In Ms. J
for
case
filing
number-
objection of opposite parties and hearing on the petition for granting injunction. Having heard the submission of Mr. Das, learned counsel for the petitioner, I have carefully gone through the petition and the documents placed on record. And also, there is the impugned order dated 5/8/2024. And also the order dated 25/7/2024. And the petition filed under section 151 of the CPC. So a submission or at arbitral line already. Mr. Das, referring to a decision of Honorable Supreme Court in
My Palace Mutually Aided Cooperative Society versus B. Mohesh and others.
my
reported in
Palace Mutually Aided Cooperative Society versus B. Mohesh and others, reported in
2022, like
2022 Life Law SC 698 submits that Section 151 of the CPC can only be applicable if there is no alternative remedy available in accordance with the existing provision of law. And since Order 39 is available, and without resorting to the same, the petitioner, the opposite party has resorted to section 151 CPC, which is, according to Mr. Das, is not at all permissible. Last to line to keep on. Also gone through the order dated 25/7/2024. It appears that the learned Civil Judge Senior Division filed order dated 25/7/2024 has fixed the matter of injunction on 22/8/2024. But before that day, on the petition being petition number 5331/2024 filed by the respondent, and without serving a copy to the present petitioner and intimating him, has passed the impugned order dated 5/8/2024 behind the back of the petitioner. by invoking the jurisdiction under section 151 CPC. Where it is well settled in the decision of Honorable Supreme Court. In My Palace Aided Cooperative Society, within bracket Supra, especially in paragraph number 28. That section 151 of the CPC can only be applicable if there is no alternative remedy available in accordance with the existing provision of law. Full stop. Such inherent power cannot override statutory prohibition or create remedies which are not contemplated under the code. Full stop. Section 151 151 cannot be invoked as an alternative to filing fresh suit, appeal, revision, or review. Full stop. A party cannot find solace in section 151 to allege and rectify strict wrong and bypass procedural safeguard inbuilt in the CPC. If we examine the impugned order in the light of the aforesaid decision, and also in the light of the submission so advanced by Mr. Das, learned counsel for the petitioner, this court is of the view that the impugned order dated 5/8/2024 failed to withstand the legal scrutiny, and accordingly the same is then set aside and quashed. Consequently, the matter remanded back to the learned trial court and to consider the same in accordance with law on the date fixed, that is 22/8/2024. In terms of above this, CRP stands at disposal at this
Deeply obliged.
motion stage itself.
Obliged.
Number 51.
Lord, I have come here, my lord, on a very, my lord, lucid question. The question is, my lord, whether, my lord, in view of provision provided under, my lord, Order 7 and Rule 11, due to non-compliance of the provisions of Order 9, whether court can exercise power to reject the bench. And what is the, my lord, mandates of Order 9, Rule 7, Order 7, Rule 9? First of all, my lord, a suit was filed by them, my lord, seeking decree for eviction and realization some, my lord, license fees. Later on, by order dated 5/8/2019, direction was given to take steps for service of notice or summons on the defendants. Now the question arises, my lord, when we received the WS, we have examined the WS, and it appears to us there is a non-compliance. And what is the non-compliance? As I understand, my lord, therefore, my lord, at this stage, it would be my privilege to take your lordship to provision. We did not file an WS, we filed an application under Order 7, Rule 11, F, with a prayer for rejection of the plaint, because there is a non-compliance of the, my lord, mandates of Order 9.
Mr. Purkayev,
My lord.
on the other day, the case was adjourned on the pair being made by you that you will produce some authorities in
Yes,
this
yes.
regard. You produce the authorities before the court.
But no, lordship, because that was heard by another judge. my lord.
Maybe,
So,
but we have to continue with that order.
no, decisions are with me, my lord, no problem. But it is my duty to, my lord, apprise your lordship what is the facts about what they look.
No, that's all right. I am aware of the facts. You produce the authorities.
Authorities then, therefore the question, first of all, my lord, I will have to take your lordship to provision, my lord. My lord, CPC, the absolute.
No, CPC is with me.
I've heard.
Hmm.
May I read, my lord? Procedure on admitting the plaint. Where the court orders that the summons be served on the defendants in the manner provided in Rule 9 of Order 5, it will direct the plaintiff to present as many as copies of the plain on plain paper as there are defendants within 7 days. Therefore, my lord, the question is, my lord, what is the time prescribed under this my lord, provision? 7 days. They took time, my lord, after 52 days. And my lord, I can understand court has got the judicial discretion. In Salem's, my lord, bar association case, Supreme Court says it will not automatically entail, it will not entail automatic rejection. Court may have the jurisdiction or judicial discretion to extend. But you have to approach the court. You have to, my lord, explain what has prevented you from taking steps. And on being satisfied, court can. And that is the view, my lord, taken in all subsequent cases. I will cite some decision. I am not going to trouble your lordship. To the option. Yes, sir. Yes, ma'am. First of all, lordship, kindly come. Salem Bar Association,
Paragraph number?
paragraph 15. I'm reading, madam.
Yes.
Our attention has been drawn to Order 7, Rule 11, to which clauses E and F, I'm covered by E and F, have been added, which another
You were reading paragraph number 15.
paragraph 15.
Yes.
Our attention has been drawn to Order 7, Rule 11, to which clauses E and F have been added, which enable the court to reject the claim where it is not filed in duplicate or where the plaintiff fails to comply with provision of Rule 9, Order 7. It appears to us that the said clauses, being procedural, would not require the automatic rejection of the claim at the first instance if there is any defect as contemplated by Rule 11E or non-compliance as referred to Rule 11F. The court should ordinarily give an opportunity for rectifying the defects. And in the event of the same not being done the court will have the liberty or the right to reject the claim. Therefore, from plain reading of this paragraph, it appears that it will not entail automatic rejection. However, court may exercise judicial discretion. But whether court will exercise judicial discretion may not either suo motu or upon application. Both the situations are not available. They didn't approach the court seeking kind, number one. Number two, it was not brought to the notice and court did not suo motu exercise the judicial discretion. Therefore, there is a non-compliance. Therefore, you cannot of your own take steps by sitting over the relevant provision. And my lord, in this regard, my lord, should kindly have, my lord, same judgment, my lord, paragraph 5. Similar provision was, my lord, that was amended, section 27. Section 27 that was amended in 2002, and objection was raised, my lord, making a prayer for declaration of section 27 as ultra vires. What is the, my lord, interpretation given? I'm just reading paragraph 5. Same is the provision, my lord. There is a statutory time prescribed. Paragraph 5. Amendment has been made to section 27 dealing with summons to the defendant, which after the amendment is as follows. Summons to defendants. Where a suit has been duly instituted, a summons may be issued to the defendant to appear and answer the claim and may be served in the manner and prescribed on such a date not beyond 30 days from the date of institution of the suit. Here 30 days is the, my lord, prescribed period. And there, my lord, 9 days, 7 days. Now what is the interpretation? Para 6. It was submitted by Mr. Vaidyanathan that the words on such day, not beyond 30 days from the date of institution of the suit seem to indicate that summons must be served within 30 days of the date of institution of the suit. In our opinion, this is the finding of the court. The said provision read as a whole will not be susceptible to that meaning. Words added by amendment. It appears fixed outer time frame by providing that the steps must be taken within 30 days from the date of the institution of the suit to issue summons. In other words, if the suit is instituted, for example, on 1st day January 2002, the correct addresses of the defendants and the process fee must be filed in the court within 30 days. So as to enable the court to, my lord, so as to enable the court within 30 days so that the summons be issued by the court not beyond 30 days. The same is the interpretation. You have to deposit, my lord, process fee, all other, my lord, particulars, along with, my lord, playing in duplicate. Therefore, once there is a lapse on your part, you did not bother to take step within 7 days, then there is a non-compliance. And what is the order of the court, my lord? Kindly see at page 20, at page 12 of the petition, Annex 1. Findings of the court is that, reason given is that since court did not fix any time, therefore, this particular provision will not come into play. What is the scope for the court, my lord, to fix time? Time is already prescribed. Kindly, my lord, at page 12. I'll take your worship at page 13, relevant portion. I have already heard the learned counsel of both the parties. Have your worship got, my lord? May I read, my lord? I have already heard the learned counsel of both the parties perused the materials on record, which reveals that suit was admitted for hearing on 8/5/2019 with the direction to the plaintiffs to take steps. Records further reveals that by the next date fixed by the court, plaintiffs had taken steps and the same was issued in due course. Record also reveals that there was no specific direction in the respect of any time frame for taking steps. Therefore, the steps which were taken, which were accepted and issued by this court is not a subject matter to be challenged subsequently by invoking provision under orders 7 Rule 9 read with vis-a-vis order 7 Rule 11F CPC. There is the matter reason given. Since court did not give any outer date, therefore steps taken even beyond 7 days cannot be challenged. Now it is for the court to, my lord, examine this question whether my submission has got any substantive, my lord, substantive force. Very small question, my lord, and court may have the judicial discretion. I am not saying court doesn't have. Court has, my lord, because no person be non-suited. You must get an opportunity, but you have to make an application. Make an application explaining the situation that it has prevented me from taking steps or I was otherwise unable to take steps, and on being satisfied, court could have granted time. You cannot sit over the relevant provision. You cannot take your own convenience. By taking your own convenience, you cannot take steps, and that too, my lord, beyond 7 days, and it was taken after 52 days. This is the submission, my lord, and all other cases also, my lord, in the similar type. Court says opportunity be given to them, but opportunity will be given to them when they approach the court with an application explaining the situation. Then only a court may exercise judicial discretion. Judicial discretion is not, I think, my lord, with humble respect, is not a tool. Somebody will appear and court will of his own exercise judicial discretion. There must have some materials. Where is the materials? You did not look into our objection. Simply says court did not fix any time, therefore motion does not arise. Does it ask for require any, my lord, require? My lord, is it the requirement of the court for the court to fix the time? Time is already prescribed. Yes, my lord, in section 27 of the CPC, 30 days summons. My lord, 7 days to deposit. So this is the humble submission. There is a non-compliance, and if there is a non-compliance, then court is empowered to reject the plaint by exercising power under Order 7 Rule, my lord, 11F. 11F is newly inserted provision giving some, my lord, authority to the court. In a given situation, court may exercise power and reject the plaint. This is my submission.
Yes.
May I please, Your Lordship? Lordship, already Lordship has gone through the provision of Order 7 Rule and 9, my lord. Wherein, my lord, this has been provided, where the court orders that the summons be served on defendants in the manner provided under Rule 9 of Order 5. It will direct the plaintiff to present as many copy of plaint of on plain paper as there are defendants
you are
within
reading?
7 days from the date of such order. My
You
lord.
are reading
Order 7 Rule 9, my lord.
Order 7
Rule 9.
rule?
Order 7 Rule 9, my lord, where the
Yes.
court orders that the summons be served on the defendant in the manner provided in Order 9, Rule 9 of Order 5. It will direct the plaintiff to present as many copies of plaint on plain paper as there are defendants within 7 days from the date of such order, along with requisite fee for service of summons on defendants. Now, Lordship, Your Lordship may cannot see what was the order passed by the trial court regarding steps, my lord. That is a page 32. After admission of the plaint. Page 32, my lord.
Yes.
Page 32, order dated 8/5/24, my lord.
Hmm.
Plaintiff is present, the plaintiff is represented, issue summons upon defendant. There is no specific direction that I should take steps within 7 days, my lord. And accordingly, date was fixed on 29/6. My lord, on 29/6, I had taken the steps and this was issued. Accordingly, defendant had appealed before the trial court, my lord. If at all, all respect and regard, my lord, there is any illegality, then those illegalities are in this order dated 8/5/19, my lord. As well as in order dated 29/6/19. These orders have not been challenged, my lord.
Hmm.
On the face value, court has accepted my process, my lord, and issued the same. Because in earlier order, there was no direction that I should take steps within such specified period. So question of non-compliance of provision of Rule 9 as provided in Order 7 Rule 9, Order 7 Rule 11 F, my lord, does not arise there, not in my case, my lord. And my lord, my process were accepted by the court and those were issued on 29/6/19, my lord. And accordingly, defendant had appealed for the trial. So this is my submission, my lord. This is not a fit case to dismiss on this technicality, my lord, because court has execution. Court has passed the order for taking step issuance of summons, and I have taken steps accordingly. The same was accepted on face value and issued the same to the defendant, my lord. Therefore, no objection.
Okay.
I will just give a reply, my lord. Just hold it. I'll just give a reply, my lord. My lord, they have specifically apprised your lordship by referring to the impugn order, saying that order dated 8/5/2019 does not reflect that court has fixed any particular time or period. And this is the order which is, they are saying, since there is no any specific time fixed, therefore it is not covered by Order 9, my lord, Order 7 Rule 9. Order 7 Rule 9, once again, my lord, let me read, my lord, for my lord understanding. While the court orders, and Order 8/5/2019 is the order. Order regarding what? Order to take steps. And here they, my lord, I am reading the order. Plaintiff is represented, issue summons upon defendant. Is it not an order? If it is an order, then period of 7 days will be counted from the date of this order. Otherwise, what is the meaning of having this particular period prescribed under the rules? It is absolutely redundant. If we say that court will have the power to override the time prescribed, then of course different question. Legislature intended to fix a particular period, a particular day with a positive intention. And court, by exercising judicial discretion without giving any reason, cannot override that statutory provision. Because the order is absolutely clear, issue summon. Therefore, I must understand this is nothing but an order within the meaning of the order of Order 9. Fine Court issued an order for taking steps. Period of 7 days will be counted from the date of that order. Is it not an order? And once court accepted these steps, it was behind your back, we are not present at that point of time. Otherwise, we would have objected. Subsequently, after receiving summons, we appeared, we filed objection. Now it is up to your lordship, my lord, whether Rule 9 has to be interpreted in such a way so that they may get an undue preference, or it has to be interpreted in such a manner as indicated in the rule itself. This is my humble submission.
And only short reply, my lord. Order 7 Rule 9 itself says court may direct the plaintiff to take steps within 7 years. Specific enough, my lord. Rule 9 is specific enough. In view of having no such direction, my lord, we've taken a step and on face bill, court has accepted the same, my lord.
You need to take steps within 7 days.
There was no direction for 7 days, my lord. This is my submission.
Okay, it's still this submission.
Okay. Person to order of this court dated 16/8/2024, Mr. A.K. Purkasto, Learned Senior Counsel, assisted by Mr. Learned Counsel for the petitioner, has produced the authorities which he had relied upon in support of the submission, no, in support of his petition. Heard Mr. Purkasto, Learned Counsel for the applicant, no, for the petitioner, and Mr. N. Alam, Learned Counsel for the respondent. Argument concluded, order is out.
Obliged.
Much.
Obliged, your lordship.
Number 9, matters for admission.
My lord, this matter may be disposed of at the admission stage on another date, my lord. So far the record from railway is concerned that I have, my lord. And so far the record of appellate court is before your lordship, my lord. This is against eviction, my lord. Notice issued by the railway, my lord. And they preferred appeal. Their appeal was rejected by the district judge, my lord. And against that order, this CRPIO is before your lordship.
Very much necessary, that was called for, my lord. Perhaps my learned
Date may fix for admission hearing of this,
for your lordship.
as per your lordship's convenience.
Correct.
For your lordship may fix for hearing also.
Admission hearing. This is not so much the time.
First week of September.
No problem.
Last part.
Yes, last part. On 26th.
As agreed by learned advocates of both the parties, recess shall list the matter on
26th September.
for admission hearing
My lord.
on that day, and report will be made to dispose of the, and endeavor will be made to dispose of the petition.
Obliged.
At number 10.
This is an appeal, my lord.
Hmm.
While under section 37 C of the Arbitration and Conciliation Act 1996 against the judgment dated 26/4/24 passed by additional district judge number 2 Kamrup, dismissing the misarbitration case 24/22 referred under section 34 of the Arbitration and Conciliation Act for setting aside the arbitral award dated 29/1/22, passed by the SOAP Forum or Conciliation and Arbitration, signed by arbitrator Mr. Mohan in arbitration petition Mr. Darcel versus Sale, my lord. The brief fact of the case, my lord, pertaining to filing of the arbitration, my lord, is as follows, my lord. Lordship may kindly Sale is one of the largest public sector undertaking of production of steel material in India, my lord. They floated a tender for shipment of their product to different destinations in the any region, my lord. Respondent being a successful bidder, enter into an agreement dated 26/3/2007, having an arbitration clause, my lord. On 30/4/2007, a work order was issued for transportation of 26.66 MT steel, valued at 9.27 lakhs, my lord, for delivery to Thaubol project at Imphal, my lord. That on 18/7/2007, my lord, entire consignment of the steel was looted on the way, my lord. A FIR has been filed after a considerable delay, my lord. And a police has filed a final report on the matter, my lord. And the sale, in the meantime, has deducted the value from the pending bill of the Darcel, my lord, the respondent, my lord, 9.9. That they moved the Honorable High Court as their application for appointing of arbitration is rejected by the sale. An application to this Honorable Court has been moved by the respondent for appointing an arbitrator. My lord, the High Court has appointed the sole scope forum of arbitration as the arbitrator, my lord. The arbitrator, after hearing the parties, my lord, make the award in favor of the respondent, my lord. That was assailed in 34 application. 34 application is dismissed. Now I am before the Honorable Court in appeal, my lord. Lordship may kindly see the agreement, my lord, 114, my lord. The relevant
Page number?
page number 114, my lord. 114, my lord.
Yes.
114. This is the starting point, my lord. Lordship may kindly see the relevant clause, my lord. Which one? 13.1 and 13.3 is the relevant clause, my lord. The transport, may I read, my lord? Lordship got it, my lord?
Yes, yes.
The transport contractor shall be liable to compensate the company for all damages, losses, and claims in respect of the damages, injuries of the steel material, or to any person, or damages to property belonging to the company, and to the rolling stock or other property belonging to the railways, whether in his possession or not, through negligence, misconduct, default, or any other act of omission and commission on his part, or that of his agents, servants, and employees. Such compensation shall be determined by the company and shall be recovered from the pending bills or the security deposit. That is the clause, my lord. Number one, that is the clause, my lord. The work order is issued at page 29, my lord, 129. Lordship may kindly see that also. 129, my lord, that is the work order. This is the work order, my lord. In reference to the tender, my lord, above you are submitted the documents indicated there. You are issuing this work order to enable to commence the work under the transportation immediately on as per annex, my lord. Thereafter, entire consignment the steel on 18/7/2007, entire consignment of the steel looted by miscreants happened to be gratuitous passenger. The driver, what they did, the driver, on the way at Gorapani in near Golaghat, my lord, he took 2 passengers, unknown passengers in the vehicle. At that, unknown passengers looted the entire consignment of the steel material. And the sale deducted the consignment. A complaint of looting by the miscreants on the way. A GD entry was made, my lord, thereafter. Vehicle was found abandoned and consignment missing, my lord. And the company, United India Insurance Company, also rejected the claim subsequently. The on 11/1/2008, my lord, incident was happened on 18/7/2007, my lord. And intimation informed the sale after 170 days from the date of the incident, my lord. Page 79 may kindly be perused, my lord.
Yes.
79, my lord. This is the letter on 11 January 2008, my lord. Steel Authority was signed by the Delhi Assam Roadways Corporation Limited, my lord. Further to your letter, we are encouraging the photocopy of the following documents: FIR, letter number auto, and inquiry report auto, my lord. These are the documents. They inform the sale after 177 days, my lord. Police cannot any breakthrough by the police, my lord. Ultimately, FIR was final report was filed, and the magistrate
Accepted the final report.
accepted the final report, page 139, my lord.
Okay, at this instance, we will admit the appeal.
My lord.
We will issue notice.
Yes, my
Or Mr. D.N. Bhattacharya,
yes, my
learned counsel for the appellant. This appeal under section 37C of the Arbitration and Conciliation Act 1966 is directed against the judgment dated 26/4/2024 passed by the learned additional district judge number 2, Kamrup M. Guwahati. It is to be noted here that by the impugned judgment and judgment dated 26/4/2024, the learned additional district judge number 2, Kamrup M, has dismissed the miss within bracket ARB case number 24 of 2022 referred under section 34 of the Arbitration and Conciliation Act 1996 for setting aside the arbitral award dated 29/1/2022 passed by the SCOPE Forum of Conciliation and Arbitration within bracket SFCA, signed by the sole arbitrator Sri B. Mohan in arbitration proceeding between the BARCL Logistics versus the Steel Authority of India within bracket side. Where is the memo of appeal and the grounds mentioned therein? Let notice be issued. Let notice be issued returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Registrar shall call for the record from the learned additional district judge number 2, Kamrup M. List the matter after 4 weeks.
I have a stay application.
Will issue notice here.
On the returnable date, it can be taken up.
Pardon?
Stay application may be taken at a returnable date, my lord.
Yes.
Let us,
Stay application will be taken up on returnable time. Issue notice in this application.
till returnable date, can it be stayed, my lord?
Let the other side appear. We'll see.
Till returnable, that if they appear, that the lordship may take other view also.
Let the other side appear. We'll consider.
They may file execution proceeding that in that case, it will multiply the proceeding, not other problem.
We'll see
So-
later on.
To prevent the multiplicity of the proceeding, my lord. Let the stay be on for up to the returnable date only. My lord.
Okay, then. Till returnable, that further proceeding of. No, but the impugned judgment and order is the state.
Of like,
Item number 11.
May I plead your lordship. Lordship, in this case, I have filed one affidavit in reply on 16 lordship that is not tagged with the record. May I plead lordship kindly take up the matter tomorrow lordship along with that track affidavit in reply lordship because my learned friend expressed some urgency lordship in this matter. So tomorrow lordship.
Tomorrow possible. Tomorrow is hearing day.
My lord, can it be taken at two, my lord, at last order, my lord, is mentioned, my lord, kindly peruse the last order, my lord.
So I have no objection.
Last
Along
order,
with
my
that
lord.
affidavit in
On 5/8, my lord, my learned friend took time, my lord, and the affidavit intentionally filed on
No, no,
Saturday,
no.
on
there is no
Saturday, my
intention.
lord.
My client came on 16, thereafter I filed lordship. No, there is no intention lordship.
On
This is very-
5/8, my lord, the order was there.
At 2 lordship, I have no objection lordship.
Okay, we'll try. At 2 p.m.
At 2 o'clock.
Yes, lordship.
In the meantime, may be called for, my lord, the
Yeah.
affidavit has been called for.
Okay.
Item 12.
Please, lordship.
Mm.
The MSc appeal pertains for the enhancement of the award granted by MSc Tribunal, Chirang. The claim amount was 20 lakhs, Your Honor, and the the award granted by MSc Tribunal is 5,59,900.
Okay. Heard Miss N. Hassan, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicle Act 1988 is directed against the judgment and award dated 10/5/2024 passed by the learned member MSCT, cum additional decisions Chirang Kajalgaon in MSc between bracket date case number 07 of 2021. It is to be noted here that by impugned judgment and award dated so and so, the learned member Motor Accident Claim Tribunal Chirang Kajalgaon has directed the respondents herein to pay a sum of rupees 5,59,900, being the compensation with interest at the rate of rupees 6% per annum from the date of filing of the application till receipt of the award. So what is the ground for enhancement?
Honor, impugned award is atrociously low, and the age of the deceased in the postmortem is called 55 years, but the tribunal assumed it 60. And there-
60.
Yes, and therefore and another ground is notional income was adopted as rupees 6,000, but it should be 7,800. And the learned tribunal wrongly decided the multiplier. The multiplier should be 11 as the deceased was 55 years of age at the time of his death, but the member of the tribunal considering it only 9, assuming his age as 60 years, which is totally arbitrary. And
Okay, Ms. Hassan, learned counsel for the appellant submits that this appeal is preferred for enhancement of the award on the ground that the learned tribunal has wrongly calculated the age of the deceased as 60 years. But in fact, as per postmortem report, the age of the deceased was 55 years, and that the learned tribunal has also wrongly calculated the income of the deceased as 6,000 per month, who is ought to have been 7,800 per month.
Actually, his income was 18,000, Your Honor. But due to they failed to exhibit any income certificate. He's a village man. He was a village man. Therefore, the learned tribunal assumed the notional income as 6,000 per month, but it should be 7,800.
And also that the learned tribunal has wrongly decided the multiplicand here in this case. The submission of Ms. Hassan needs further consideration that this is this notice be issued to the respondents return admit. Notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by result process within a week from today. Rest shall call for the record from the learned member MSCT Kajal Siram Kajal Gaon. List the matter after 4 weeks.
Highly obliged.
Lordship, on the ground that the Lordship will find the final assessment at last page of the award. It was 36 lakhs 34,634, amputation of a hand, Lordship. And tribunal has awarded some compensation under the head of failure, 2 lakhs, future prospect 2 lakhs. These are the extra. We'll deposit 20 lakhs before the registry, Lordship.
Okay. So what are the grounds according to you?
Lordship, there are apparent mistake regarding some apportionment of the award. Lordship will find at the last page of the judgment.
Yes.
Award was 36 lakhs 34,634. Lordship will find pain and shock suffering, mental agony 2 lakhs. Future treatment 2 lakhs. Loss of enjoyment of life amenities 3 lakhs.
What was the direction of the constitutional bench decision in Pranay Sethi?
Not only Pranay Sethi, this principle has been laid down by the Supreme Court in the case of injury case. This is an injury case. Supreme Court has categorically stated when disability is more than 50%, there is no question of awarding compensation for pain and shock and suffering.
This is
Loss
not
of-
a death case. This is not a death case.
Not this case, injury case, amputation of a hand. These are the extra award has been assessed, Lordship. When the future loss of income has been assessed as rupees 20 lakhs, and thereafter this compensation only for pain and suffering, only award can be passed. Thereafter, Lordship, loss of
Whether
enjoyment,
there was any disability certificate?
disability certificate, amputation of right hand, Lordship. Amputation of right hand.
Right hand. What was the profession of the
24 years boy. According to them, he was a mason. No income certificate, no document to prove that he was a mason.
Okay. Heard Mr. S.K. Goswami, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicle Act 1988 is directed against the judgment and award dated 7/6/2024 passed by the learned member, Motor Accident Claim Tribunal, Kamrup M. Guwahati in MSC case number 586 of 2018. It is to be noted here that by the impugned judgment and award dated so and so, the learned tribunal has directed the appellant to pay a sum of rupees 36 lakhs 34,634, being the compensation to the respondent. To the respondents. peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and award dated 7/6/2024. Admit, let notice be issued to the respondent returnable in 4 weeks. Step be taken by registered post and also by usual process within a week from today. Call for the call for the record from the learned member, MSCT Kamrup Guwahati. In IA আগৰ ফৰ্মেটটো আছে নহয়। So 50% on depositing 50% of the awarded amount before the rest of this court, the impugned judgment and award dated so and so is stated.
We'll deposit more lots, 20 lakhs lots.
20 lakhs.
20
Okay, 20 lakhs. Submission to লিখি দিব, Mr. Goswami, learned counsel for the applicant submits that the applicant will deposit a sum of rupees 20 lakhs.
Within 4 weeks lots.
I need to display.
How will I?
Learned member.
That case,
It's an injury case, Lordship.
injury case,
Yes, without evidence of doctor, Lordship. The learned member.
without evidence of,
Doctor, Lordship.
Ah.
It's a non-civil injury, Lordship. And evidence of doctor is must, Lordship. Here, without any evidence of doctor, the learned member assessed the injury, that is functional disability, at 40%, Lordship. And accordingly awarded the compensation of rupees. Lordship will find the total compensation.
16 lakhs,
Yes, Lordship. At page 34.
39,000. Okay.
In the
Heard Miss M. Sutter, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicle Act is directed against the judgment and award dated 10/5/2024, passed by the learned member MSCT Kamrup, MSCT number 3 Kamrup M. Guwahati in MSC case number 1821 of 2018.
1821.
It is to be noted here that by the impugned judgment and award dated so and so, the learned tribunal has directed the appellant insurance company to pay a sum of rupees 16,39,565, being the compensation to the claimant stroke opposite party respondents herein. Within a period of 30 days from the date of pronouncement of the judgment, and further directed that the amount shall carry interest at the rate of rupees 9% per annum from the date of filing the claim petition. Peruse the memo of appeal and the grounds mentioned therein. Admit. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Registration call for the record from the member, learned member MSCT number 3 Kamrup M. Guwahati. Stay 50%.
Lordship.
I display.
Item 15.
Lordship, MSCT case number is 1821 of 2018. 1821 of 2018.
Yes.
Obliged, Lordship.
Item 15.
My friend Lordship, this is an appeal filed by the insurance company, Lordship. Actually, the judgment and award of MSCT number 2 Kamrup Metro, Lordship. It's an injury case, Lordship. The award has been awarded rupees 16,95,817, Lordship. And here the main ground of challenge of this judgment and award is that disability certificate, Lordship. We had raised serious doubt over the disability certificate, Lordship, in our cross examination, but the same was not considered, Lordship. And even in the judgment also, the same was not discussed, Lordship. And we have filed our written argument also assailing this disability certificate, authenticity of this disability certificate, Lordship. And there are certain contradiction in the disability certificate, Lordship, because this was from the cross examination itself. Lordship may produce the cross examination part, that is page number 30 to 31 Lordship, this disability certificate was not issued as per the guidelines, Lordship. May I come to page number 30, Lordship? I have the guidelines of Lordship. I'll forward it. Lordship, got it 30, page number 30. That is the clause, page number 30, Lordship. In exact. That cross examination part, Lordship. May I read, Lordship?
Not necessary.
Lordship, I have the guideline also. In the hearing, I'll definitely.
So it is, we will admit the appeal.
Any time it will be admitted, Lordship.
50%.
The other side also.
50% maybe.
Pardon?
50% maybe till this disposal value. 50%.
Pardon?
50% amount maybe given by.
50%.
ST petition has been
50%. Okay, deposit of 50%, but there is no pair for staying
I have in my appeal itself, there is a.
ST petition.
in the appeal itself. Okay. Heard, Mr. PJ Burman, learned counsel for the appellant. তাৰ আগতে এটা লিখি ল'ব caveat stands research 450 of 2024. Heard, Mr. PJ Burman, learned counsel for the appellant, and Mr. S. Rahman, learned counsel for the caveat respondents. This appeal under section 173 of the Motor Vehicle Act is directed against the judgment and award dated 12/12/2023 passed by the learned member MSCT number 2 Kamrup M Guwahati in MSC case number 96 of 2021. It is to be noted here that by the impugn judgment and award dated so the learned member MSCT number 2 Kamrup M Guwahati has directed the appellant insurance company to pay a sum of rupees 16,95,819 with interest at the rate of rupees 9% per annum from the date of filing of the evidence and affidavit, that is 9/9/2022 till payment. Where is the memo of appeal and the grounds mentioned therein? And also where is the impugned judgment and award dated source? This appeal is admitted for hearing on depositing 50% of the awarded amount before the registry of this court within a period of 2 weeks from today.
Logic.
2 weeks from today.
And on such defeated by the claimant may be allowed to request.
Issue notice to the respondents. Returnable in 4 weeks. Since Mr. Rahman, learned counsel for the respondents, you are for all the respondents.
1 and 2 by the claimant by the
1 and
2 claimant.
1 and 2. Since Mr. Rahman, learned counsel for the respondent number 1 and 2 entered appearance and received notice, no formal notice is required to be issued to him. No formal notice is required to be issued to the respondent number 1 and 2. However, extra requisite copy of the petition be furnished to Mr. Rahman during the course of the day. Step upon respondent number 3 and 4 be taken by registered post with AD and also the usual process within a week from today. Registrar call for the scanned copy of the record. No, sorry. Registrar call for the record from the learned member MSCT. What? Mr. Rahman, learned counsel appearing for the respondent number 1 and 2 submits that the respondent number 1 and 2 may be permitted to withdraw their share of the 50% of the awarded amount.
Subject to a bond loss.
Yes. Their share of the 50% of the amount, which is directed to be deposited before the registry of this court. Here is accordingly allowed on executing a bond. The said amount be released in favor of the share of the respondent number 1 and 2 be released in their favor. In terms of above, no, not Please, Dr. Forex.
In this case, what happened, my lord? The actually claimant, original claimant is one, my lord. He is representing by his mother, claimant of two, my lord. So the claimant number one may be allowed to do this.
Okay, claimant number one, not two. Claimant number two is minor.
Mother, my lord. He is representing the claimant
Mother.
claimant one.
Mother. Okay, claimant number one.
One, my lord.
No, as claimant number two, no, as respondent number two is being represented by the respondent number one. She may be allowed to withdraw the amount on behalf of the respondent number two.
The judgment may be state also.
Operation of the interim judgment and order that is going for state.
Highly open.
Item for bail hearing, item 16.
Here, updated diary was called for. Diary is not updated, my lord. He is in interim, my lord. His statement is not there in the diary.
But today and on two previous occasions also, the applicant remain absent.
Yes.
What to do? None appears for the applicant on call. It appears that on 9/8/2024 and 24/6/2024 also the applicant remain absent and remain unrepresented. Place the matter after 1 week. In the event of subsequent non-appearance, non-representation, appropriate order shall follow.
Item 17.
My lord. Interim bail was granted in this case, but the
Here
applicant.
also, my lord, that
applicant
diary,
is
my
not
lord,
available.
in fact, my lord, they sent a wrong diary, my lord. Updated diary was called for, my lord. He is in interim. That, my lord, same
No,
time,
he
another case
is
was
not
there.
on interim. The
Yes.
interim order was recalled.
Oh. Okay.
Heard Mr. D. Goswami, learned counsel for the applicant, and Mr. B.B. Gogoi, learned additional PP for the state respondent. Mr. Gogoi submits that updated case diary was called for from the concerned IO, but the IO has sent the wrong case diary and press for granting him. From where it will come?
Dispute.
Dispute. On Thursday?
Yes. On 22nd.
Accordingly, it is provided that Mr. Gogoi shall produce the case diary before this court on 22nd.
22nd.
Okay.
Items for hearing under order 41, rule 2, CPC, item number 20.
Please, my lord.
Hmm.
I'm preferring this second appeal on being aggrieved by the order dated 14/8/2023, passed in title appeal number 6/2022 by the learned civil judge. So there is a concurrent finding, my lord, by both the courts. I was the plaintiff in the original title suit. The suit has been dismissed as well as the appeal also has been rejected, my lord. May I please take my lord to the title suit, my lord?
What are the substantial question of law?
My lord will find it page number 8. The first substantial question is law is that, my lord, there has been the basic allegation in this contention in this particular title suit is as regard to a Sitha Namzari, my lord, which has been done without there being any registered, my lord, sale deed executed by the original owner, performer defendant number 2, and the the defendant number 1, my lord. Defendant number 1 and myself, my lord, we are brothers, and the land was originally owned by the performer defendant number 2, my lord. So, my lord, on the basis of merely a noting, my lord, without there being any registered instrument, the Sitha Namzari has been done, my lord. That is the crux of the issue, my lord. And the prayers in the title suit, my lord, will find it page number 12.
Page number?
Page number 12 is the prayer, my lord, of the title suit.
But the problem is that there's a substantial question of law you have framed
My lord.
in sheet number, in page number 8.
Yes,
It is not part of the memo of appeal.
my lord.
You have enclosed it. But as per requirement of subsection 3 to section 100, it has to be incorporated in the memo of appeal itself.
My lord.
What to do?
I have otherwise, I have another, my lord, I framed, there are certain defects in this particular matter memo, substantial question of law. If I may submit, my lord, the
Yes.
substantial, my lord, questions of law. To the court, my lord. There are certain errors, my lord. The section 17 and 49 both were required, my lord, because ignoring that these particular provisions, my lord, the order and judgment has been passed. Judgment and decree has been passed by both the courts, my lord, saying that Sitha Namzari has been done, my lord, and where the registration is not at all required. If I may take, my lord, to the judgment, my lord.
But Mr. Counsel, you file amended this memo of appeal incorporating these two substantial question of law in
file
the
them, madam. I'll
appeal
file,
itself.
I'll file this too.
On the pair being made by Mr.
R. Sensual.
R. Sensual, learned counsel for the appellant. Rest shall release the matter after 1 week,
After 1 week.
so as to enable him to incorporate the substantial question of law in the memo of appeal itself and to file the amended memo of appeal. Here is accordingly read the matter after. So do we fix it or only
It may come up, my lord.
1 week?
My lord may fix a date as, my lord.
1st September. 1st of September.
My lord. Replicable.
Item 21. Want to take back the
No,
question?
my lord. Otherwise, I'll.
21.
May please look at. My lord, the original of my lord, I am the plaintiff, my lord, and I have lost in both the courts. I have lost in both the courts below, my lord, concurrent finding of that.
Mm.
My lord, is suit of the plaintiff is, my lord, for declaration of right return interest and for permanent injunction, my lord. Substantial questions of law involved to my limited knowledge, my lord. Lordship will find page 4. B and my lord, E is my lord, related. Because the, my lord, page number 4, my lord. B and E, my lord. And E also, my lord. But I have a bill, but my lord, that has not been disputed and challenged, my lord, by anybody, my lord. So, my lord, both the courts below, my lord, without considering that part, my lord, only
You have framed as many as 9
my lord,
substantial
only two,
question
my
of
lord, I
law.
am pressing, my lord. My lord, B and my lord, E, I am, my lord, pressing.
Pardon?
B, my lord, E,
B and E.
E. E for England.
Yes, madam.
Can I call for the records?
You are for respondents.
Yes, I'm for the Forest Department, Your Lordship, respondents number 1, 3, and 4.
1, 3, and 4. Heard Mr. R. Sharma, learned counsel for the appellant. And madam, good name,
M. Kalita, your lordship.
N. Kolita,
For the respondent.
learned counsel for the respondent number 1,
3 and 4, your lordship.
3 and 4.
Lordship, I am appearing for respondent number 2.
This appeal under section 100 of the Code of Civil Procedure is directed against the judgment dated 4/5/2024 and the decree dated 13/5/2024 passed by the learned civil judge, Senior Division Lakhimpur, in title appeal number 7 of 2022. So it is to be noted here that by impugned judgment and decree dated so and so, the learned civil judge, Senior Division Lakhimpur, has affirmed the judgment dated 4/6/2022 and the decree dated 10/6/2022 passed by the learned Munship number 1 Lakhimpur in titles of number 39 of 2021. Here is the memo of appeal and the grounds, no, and the substantial question of law. Incorporated therein. Having heard the submission of learned advocates about the parties, this appeal is admitted for hearing on the following substantial question of law. 1. Whether the learned lower appellate court, the first appellate court, committed illegality in dismissing the suit of the appellant struck plaintiff in as much as the appellant plaintiff has valid right, title and interest over the suit land, having valid patra issued in his name, and the same has not been challenged and or rebutted by anybody, including the respondents, defendants. Number 2, whether the learned courts below committed illegality in dismissing the suit of the plaintiff, appellant struck plaintiff without considering the Exhibit 7, Exhibit 9, and Exhibit 10. Those were issued by the circle officer,
Yes, my lord.
issued by the circle officer, Kadam Revenue Circle, Baginodi, which clearly states the title of the appellant struck plaintiff over the suit land and encroachment of the suit land by the respondent struck defendant. And also on any substantial question of law that has come in the time of hearing after giving notice to the other side. Since no, issue notice since means so and so learned counsel appeared on behalf of respondent number 1, 3, and 4. No formal notice is required to be issued to her or issued to the said respondents. However, extra requisite copy of the appeal be furnished to the learned counsel during the course of the day. Notice to the other respondents be issued to the issued by registered post with AD and also by usual process within a week from today. Call for record from the call for the record from the learned courts below. List the matter after 4 week.
My lord, for respondent number 2, my lord, government may accept.
What's that? Madam, your good name?
B. Deca.
B. Deca, learned counsel for the respondent number 2. Notice. Not necessary. After 4 weeks.
Obliged to you.
Item 22 for orders.
May I bring your lordship?
Yes.
This, in this case, Mr. First appeal, the appellant number 1 died. And we have the information that his son surviving also died in the last month. So we require some time to collect the
addresses of the next kin of the appellant number 1.
Okay, heard, Mr.
A Thakur.
A.
Thakur.
Sattar.
I am called to respondent number 2, Lordship. On behalf of HK Burua.
What was the name? Acha. Learned counsel for the appellant and Madam
Respondent number 2, M. Bora.
M. Bora, learned counsel for the respondent number 2. Mr. Thakur, A. Thakur, learned counsel for the appellant submits that respondent number.
Appellant number 1.
Appellant number 1 suffered demise. And he may be granted some time to collect. What time is required?
To substitute his wife and daughter who are not staying in, I suppose not in Assam. I'll have to collect the address.
That he required some times to collect the address of the legal heirs of the respondent number 1. No, appellant number 1.
Appellant.
Here is accordingly allowed. Recessal is the matter. After 2 weeks,
No, my lord, 4 weeks.
4 weeks.
Any date may be fixed, Lordship.
11 September.
11 September.
23.
May it please your Lordship. Lordship, this LCR has been received and respondent number 1 has entered appearance. Matter is ready regarding service and records.
You go for respondent number
1, my lord.
1. How many respondents are there?
There were
Three.
3 respondents, 2 and 3 were struck off, Lordship.
Track of
Yes, Lordship.
heard Miss
M. Saikia, Lordship.
M. Sukia, learned counsel for the appellant, and Mr.
B. Bora. B. Bora.
P. Bora, learned counsel for the respondent number 1. Ms. Sukia, learned counsel for the appellant, submits that here in this case, service completed and the matter is ready for hearing. Accordingly, it is provided that recessal is the matter for hearing in usual course.
My lord, finally, on 14th of September, there is also Lok Adalat.
14th of September.
Let this matter.
Later on, learned counsel for the respondent submits that the matter may be listed before the Lok Adalat to be held on 14th of September 2024. Where is accordingly allowed, recessal do the needful in this regard.
Okay, sir.
24. May I explain the matter? My lord, there is an office note, my lord, dated 16/8/2024, my lord. So far as the respondent number 1 is concerned, my lord, is not found as residing at Guwahati, not found as residing in Guwahati. And similarly, my lord, 1B refused to accept. 1C not found as residing at Guwahati. So refusal amount to my lord acceptance, so far as the 1B is concerned.
So 1B and 1C duly served.
No, there are two 1B, 1C. Kindly see the cost title, my lord.
My lord, 1B, 1C, 1B, my lord, Sri Samiran Chakravarti and Srimati Binapani Chakravarti, my learned friend is appearing, my lord, on their behalf. And so far, 1A, my lord, 1B and 1C, 1B, my lord.
1A Roman 1, 1A Roman 2, 1A Roman 3.
My lord.
They have not been found in the address.
Lordship. So I shall have to take fresh steps.
Fresh is there.
So far as the two respondent is concerned, and refusal, my lord. One is refusal.
Heard Mr. T.U. Ahmed.
T.U. Laskam.
Oh yes, law scholar, learned counsel for the appellant. Mr. S.K. Ghosh, learned counsel for the respondent number.
My lord, the kindly name may be reflected, the party's name, because. he has
Okay,
mentioned
for the
218,
respondent
1B.
number.
Somiran Chakraborty and Bina Banisha.
Respondent number, respondent Somiran Chakraborty and Binapani Chakraborty. Respondent number
1A, 1B.
1A and 1B. 1A and 1B. Office note dated 18/9/2019. No.
16.
Office note dated 16/8/2024 indicates that notice issued to the respondents number A1, AB, no, 1A, 1B, 1C. 1A returned with a report that not found, as the respondent is not residing at Guwahati. And notice issued to the respondent number 1B returned with a report that refused to accept the notice. And respondent number R1C returned with a report that not found, as the address is residing at Guwahati. The learned counsel for the appellant submits that as respondent number 1B refused to accept the notice, the same deemed to have been served upon him, and that he will take fresh issue upon respondent number 1A and 1C. Accordingly, it is provided that notice to the respondent number 1A and 1C be issued by registered post with AD and usual process within a week from today. Notice upon respondent number 1B deemed to have been served, as he refused to accept the same. List after 4 weeks.
Like 25. This is an application for substitution. The original applicant had passed away. And we have filed the
When?
application on 12/1/2022. Death certificate we have annexed to the IF.
Heard, Mr.
A. Ganguly.
A. Ganguly. Learned counsel for the applicant and madam.
D Mohanta.
Learned counsel for the respondent. Opposite party. This application under order 22 rule 10A read with rule 3 and section 151 of the CPC is preferred by the applicant for substitution of legal heirs of the deceased appellant Habizuddin Fakir. The learned counsel for the applicant submits that appellant Habizuddin Fakir in RSA number 112 of 2021 passed away on 12/1/2022, leaving behind his wife and 8 sons and a married daughter as his legal heirs. And the same has been duly reflected in para number 4 of this application. And accordingly, it is submitted that the aforesaid applicants, namely so and so, total number 10, may be implemented as the appellant in RSA number 112 of 2021. Any objection? The learned counsel for the respondent submits that opposite party submits that she has no objection in the event of allowing this application. Having heard the submission of learned counsel for both the parties, I have gone through the petition and the documents placed on record. Annexure 4, Annexure A, enclosed with the petition at page number 8 reflects that Hafizuddin suffered demise on 12/1/2022. And it also appears that he left behind as many as 10 legal heirs, namely so and so, so and so. Accordingly, it is provided that the name of aforesaid legal heirs be substituted in place of Hafizuddin Faqih, the appellant in RSA number so and so, so and so. In terms of above this, I instance, this was open. So raise the statutory law, raise the law, issue, raise the law. Raise the to do the needful in this regard.
Lordship, the matter may be fixed for hearing, Lordship.
We already, the substantial questions of law are already framed, my lord, and the matter is otherwise admitted for hearing.
It has not been admitted.
No, it has been admitted, and substantial questions of law have been framed.
Frame.
Framed.
Then where is the question for readmission? Hearing. Next that will be for hearing.
Public.
এটা ওটা করবো না?
Your lordship, claimant number 1, that is respondent number 1 has expired, your lordship. And next of kin, that is his major son and daughter, are already in effect, your lordship. The name of claimant number 1, that is Buddha entity, may be deleted.
My service is not complete on respondent 4 and 5, my lord. My lord, kindly allow us to take service of notice on 4 and 5 justice service, my lord.
Heard Miss
El Sharma.
L. Sharma, learned counsel for the appellant, and Mr. A.N. Iqbal,
Yes, your lordship.
learned counsel for the respondent number 1 to 3.
1, 2, 3, and 1 has expired, your lordship.
One is expired.
1 has expired. And 2
Mr.
and 3 are
Iqbal
pending.
submits that respondent number 1 suffered demise on when?
Your lordship, during the pendency, your lordship, 2-3 months ago. your
During the pendency of this appeal. But you submit the particulars, whether implement is necessary, legal heirs.
They are
Already,
next of kin are already in effect, your lordship. Claimant number 2 and 3 are already the next of kin, your lordship. Major son and major daughter.
Next of
2,
kin.
3 and
Next of
2
and 3, your lordship.
The learned counsel for the respondent number 1 to 3 submits that respondent number 2 and 3 are the next to kin of respondent number 1, and they have been representing respondent number 1. Office note dated 14/8/2024 indicates that LCR has not been received till date, and AD card in respect of respondent number 4 and 5 has not been received till date. The learned counsel for the appellant submits that she will take fresh step
yes, ma'am.
upon respondent number 4 and 5.
4 and 5.
Step be taken by registered post with AD and also by usual
With justice
person
service, my lord, because they
or
are
within a
local,
week
my lord.
today. Dusty is also permitted. SSL also is a reminder to the learned
Motor accident number
member MSCT
number 1.
number 1 Kamrup and Guwahati for transmitting the record immediately.
Oblige.
Oblige.
27. Wait, please, Lordship. Here in this case, Lordship, as per office note dated 9/10/23. Response number 1, 2, 4, and 5 has been duly represented. So far as response number 3 is concerned, Lordship, no ID card has been received back. And as per process server report, office note dated 14/8/24. Response number 3 could not be tested out. Lordship, response 3 is driver. We have challenged yet one term only. So driver is not necessary, but his name may be Strapper.
Strapper. Heard Mr. M. Talukdar, learned counsel for the appellant, and Ms. L. Sarma, learned counsel for the respondent
Number
number.
1, insurance.
You are for respondent number, madam?
1,
1.
insurance, madam.
None appears for the respondent number 2, 4, and 5. Office note dated 14/8/2024 indicates that notice upon the respondent number 3 could not be served as he could not be traced out as per report of the process server. The learned counsel for the appellant submits that the respondent number 3 is a driver, and as in this appeal, only the quantum is being challenged. The name of respondent number 3 may be struck off from the array of this appeal. Here is accordingly allowed. List the matter for hearing then.
Lordship, hearing this case, Lordship, respondent number 4 and 5 have filed objection in MEC appeal number 12. In your appeal, they have filed objection. Lordship,
Yes.
we will file reply to that objection. Affidavit in reply. And further, they have also filed in this case. Lordship, kindly see IAC bill number 2983.
Yes.
Here we will also file objection. So maybe allowed to come sometime 2 weeks time and maybe allowed.
Mr. Talukdar, learned counsel for the appellant submits that the respondent number 4 and 5 filed their written objection, and he will file a reply to the same and write for granting him some time. Here is accordingly allowed. Recessal is the matter after 2 weeks. 2 weeks.
And Lordship, again, in IAC bill number 2983.
Yes.
Here also we will file objection.
In I number so and so representation same लिखियो. Mr. Talukdar, learned counsel for the applicant. Who filed this IA?
Lordship, respondent number 4 and 5.
Submits that he will file a reply to the
Objection, we will file
objection
Yeah.
filed by the respondent number 4 and 5 and price for granting him some time. Here is accordingly allowed. Recessal is the matter after 2 weeks.
Objection.
28.
May I please your lordship?
Yes.
Lordship, this this petition was filed by the appellant.
One A to 1C is repeated.
Mr. Sohan, you were for respondent number 1 A and 1C.
A, B, C. Yes.
Heard Mr. A. Rahman, learned counsel for the petitioner, and Mr. Sohan, learned counsel for the respondent number 1A, 1B, and 1C. Office note dated 16/8/2024 indicates that service report in respect of respondent number 2A, 2Z, 3A, and 2A, 2Z, and R3, no, and 3A to 3E. কি বুলি start কৰিলো লাইনটো? Have not received back by the registry. So have you taken any step?
I don't think bioaccusion was taken, my lord, but
When?
I had to take a register.
So now what to do? You want to take fresh step?
My lord, I will take.
My lord, both way, my lord. By register as well by my lord.
My lord.
Mr. Rahman, learned counsel for the petitioner submits that he will take fresh step upon respondent number 1A to 2Z and 3A to 3E by registered post with AD and also by usual process within two working days from today. List the matter after 4 weeks.
Interim may be continued. Interim may kindly be continued.
Till then, interim order pass earlier self-containing.
Apply, sir.
Okay, on the prayer being made by Mr.
Yes, Islam.
Learned counsel for the applicant, recessal is the matter after
Thursday.
Thursday.
I did realize.
Okay.
Timing item number 5. May I please, your lordship. Lordship, the petitioner is the defendant in the suit, your lordship. They has challenged the impugn order dated 37/24, page 52, annexure 5, your lordship.
Yes.
The petitioner has filed an application under Order 26, Rule 9, your lordship, for local investigation. That was rejected only on the ground that evidence of DWs are complete. Your lordship, kindly see the impugn order, your lordship. Both sides are represented by their counsel. Today was fixed for hearing on instant misdemeanor case number, whereby the defendant petitioner prayed through her learned counsel to appoint a commissioner for local investigation of the subject matter, more specifically to ascertain if rooms rented to defendants are RCC rooms of the same building and if connecting corridor of the rooms were demolished by the new purchaser and when new purchaser had put boundary walls. Learned counsel for the plaintiff objected to it by filing written objection. Perusal heard both sides. On perusal of seer and after hearing both the sides at length, this court is of the view that evidence of DWs have been closed and the instant suit was supposed to be posted for argument, and at this stage this petition is filed. However, this court is not inclined to allow the petition. As because lordship,
So what is the purpose for appointing a commission?
yes, your lordship, my petition, kindly see your lordship, page 44. The fact of the case is paragraph 2, your lordship. I took 2 rooms, your lordship, on rent, your lordship. Paragraph 2, page 44, lordship, found it. That the contention of the petitioner defendant in this instance suit is that she took 2 rooms on rent from the plaintiff. One RCC and the other is of asbestos roof. The RCC room is in front side facing PWD road, where she started a pharmacy, and the other room with asbestos roof is little away from the RCC room, which is used as storeroom. There were corridor verandas that is in the back side of the front room and on the north side of the asbestos roof room, through which the petitioner defendant and her men used to go to the backside room and vice versa. Adjoining land of the plaintiff in the backside of the RCC room, a plot of land of his relative who sold out his land to one Sukumar Das. On measurement of both the plots of his land, both the plots of the plaintiff and his relatives, it was found that corridor veranda land falls into the land of the relative of the plaintiff. It was mutually settled in between them, and corridor verandas were broken and land was handed over to the new purchaser, who put walls on the boundary of his land, resulting blocked of entrance of the petitioner defendant from her to the rear room and vice versa. In putting a wall, temporary gap is left by new purchaser for the petitioner defendant for her passage to the rooms. This incident was in the year 2015, and for this rent of the rooms were reduced from 2,600 to 2,500. What happened, Lordship? The plaintiff sold a part of his share of land, and for that reason, the corridor, the passage was blocked, and they were mutually agreed that after some time it was settled, and he will give another passage. But instead of that doing, he filed the instant suit, and in his evidence, he did not disclose all these things, Your Lordship. So I pray for local investigation, Your Lordship. And Your Lordship, the application can be allowed at any stage of the suit. It is not that plaintiff DW is closed, so it cannot be allowed. Only ground for the rejection of this application is that DW evidence is closed.
The suit was for ejectment?
Yes, Your Lordship.
So what purpose will be served by suing the commission?
Lordship, the plaintiff has deposed that and pleaded that the only RCC rooms were given on rent, and there was no passage of that. That was not disclosed. Only because the plaintiff did not plaintiff sold a part of land, he did not want to extend the agreement of the defendant, Your Lordship. And the defendant petitioner is earning from her shop and earning his livelihood, Your Lordship. There is no defaulter. She's paying the rent, Your Lordship. And bona fide requirement is also not there, because he is giving another plots of shops on rent, Your Lordship. In our High Court, Your Lordship, it is paragraph 15, 16, and 17. Fif 15, Lordship, paragraph. Under order 26.
You have mentioned in the petition that the suit was for recovery of area rent also.
No, Lordship, as per instruction, Lordship, I am paying the rent regularly, Your Lordship. Yes, area house rent is also there.
Then,
But your lordship, this particular application, your lordship can be, it is not that if it is allowed, the other side will be prejudiced. No such observation is given in the impugn order, your lordship. Only reason was shown that
no, in the order, the learned trial court has stated that after hearing the argument, if the court feels the necessity to appoint a commission, then that can also be considered.
lordship kindly see my petition. I have stated page 44, 45, your lordship. Kindly see my petition. I have there is paragraph 2, lordship. Plaintiff, the PW1 in cross says that I rented 2 RCC rooms to the defendant. PW2, he also stated in his chief says some years back the defendant took 2 rooms on lease of the said RCC building. 1 room in front side and another room is
So
in
whether
the lease.
there was any agreement between the petitioner and the respondent?
Yes, there was agreement and that
Have you
was
enclosed the agreement with this application?
no, that was not annexed, your lordship.
You produced the agreement before this court?
In the WS also, lordship, I have pleaded. In the petition, lordship, I have in
No, you produced the agreement before the court on next date. Pardon me, sir, your good name?
AR Shom, lordship.
A.R. Som, learned counsel for the petitioner.
On an agreement.
Recessal list the matter on Thursday,
Lordship.
so as to enable the learned counsel to produce the agreement, rent agreement between the petitioner and the respondent before this court.
Timing item number
All
11
right, your lordship.
for admission.
May plead your lordship.
Yes.
Lordship, in this case, what happened, lordship, husband filed a suit, lordship, seeking divorce, lordship. I am for, why filed a the petition for divorce? I am for the husband, lordship. In that case, on particular date, lordship, that is on, lordship, last date, lordship, it was fixed for cross-examination of PW1 and 2, lordship. On that date, I have filed one application seeking adjournment, lordship. My application was rejected, lordship, and cross-examination of PW1 and 2 was discharged, lordship. Lordship, kindly peruse the impugn order at page 54, lordship. Except 14, page 54. Small order, may I read, lordship?
Yes.
Petitioner is present with her witness. Respondent is absent. However, his engaged counsel amicus curiae filed petition number so stating that ground of absence of the respondent. On perusal of the case record, it is seen that the respondent remained absent since 1/9/2023 with steps one after another by his engaged learned amicus curiae. Today also his engaged amicus curiae has filed petition number showing the ground of his absence which cannot be considered without medical document. As such, prayer made in the petition number is rejected. The petitioner has filed petition number stating that now PW3 is not available to face cross-examination. Hence, she has to expunge the examination in chief in the affidavit of the PW3. Considering the ground, her prayer is allowed and examination in chief in affidavit of PW3 hereby expunged. On perusal of the case record, it is seen that the petitioner and her witnesses have submitted their examination in chiefs in affidavit as PW1, 2, and 3 on 4/5/2023, along with the copies thereof. But till today, the respondents did not receive the copies of PWs to cross-examination them, which shows negligence to proceed the case on part of the respondents. Today also, the petitioner is present with her witness, that is PW2, but they did not could not cross-examine due to absence of the respondent. Hence, PW1 and PW2 are discharged without any cross-examination. I have challenged this order, Lordship. Here, Lordship, the learned trial court, Lordship, mentioned that petitioner remained absent since 1/9/2023. In fact, 1/9/2023, the case was not fixed for cross-examination, Lordship. Case was fixed for cross-examination. Lordship, I had order dated 15/9/23. Lordship, kindly peruse page 43, Lordship. Page 43, this is the order dated 15/9/2023. Lordship, kindly straightaway go to page 47, last part, Lordship. On perusal of the case record, it is seen that the petitioner objector already filed the examination in chief of her PWs, which have already been received by the respondent petitioner, fixed 8/12/2023. So, for the first time, it is fixed on 8/12, Lordship. On 8/12, Lordship, next page, Lordship, page 48, Lordship. Petitioner is present along with PWs 2. On perusal of the case record, it is seen that inadvertently it was written that order dated so and so the respondent already received the copies of the PWs, but which are not yet to be received. Respondent is absent with steps cause shown by petition number so and so, praying for another date, prayer is allowed. On that date, I prayed for adjournment, that was allowed. And next date fixed on 21/2024. On next date, Lordship, kindly peruse, Lordship, page 51, Lordship. Case record is put up today as the course work disrupted due to the pen down strike called by the All Assam Judicial Employees Association fixed on 23/2024. So only one date, Lordship, I took adjournment, that is on 8/12/2023. And on next date, Lordship, that is 20, I filed this application, page 52, Lordship. Page 52 is my application.
52.
This is the translated copy, Lordship. Originally is page 53. And that was rejected by the improving order dated 23/2024. So after fixing the date of cross-examination, only one date I took adjournment, and on last date, Lordship, I filed the application, and that was rejected and discharged the cross-examination of PW1 and 2. In fact, Lordship, RDR also, Lordship, the learned trial court stated that the earlier occasion we have on law took adjournment, but Lordship, kindly say from Annexer 1, I have annexed all the order sheet, Lordship. Relevant order sheet, Lordship. Annexer 1, Lordship, page 15. 11/11/2019. Issues were framed, Lordship. Issues were framed on 11/11/2019, page 15.
50.
15. It was fixed on 23/12, Lordship. Then on 23/12, Lordship, page 17. Next date fixed on, Lordship, 31/3/2020. Thereafter, due to COVID pandemic, Lordship, that matter was not taken up for some long time, Lordship. Thereafter, Lordship, on Lordship, kindly go to page 20, Lordship. 2/3/2023. In the meantime, Lordship, our respondent wife filed one petition for amendment of the plaint, and on 2/3/2023, that amendment of the plaint was allowed, Lordship, by the learned trial court. 2/3/2023.
What is your submission?
My lord, my submission is that, my lord, there is no wrong on the part of the my learned trial court, because, my lord,
what happened, my lord, the respondent husband, my lord, in the year 2019 itself, my lord, after filing of the divorce petition, my lord, they are separated, my lord, from the 2016, my lord. That is for the last 8 years, my lord. They are separated. So after filing of the divorce petition, immediately, my lord, he within that year he performed a second marriage, my lord. In 2019, my lord, he performed a second marriage. But my lord, after that, for the last 5 years, my lord, he has been lingering the case, my lord. I have the original certified copy of the lower court, my lord. If your lordship peruse, my lord, that out of this trial proceeding, my lord, 25 times, my lord, he remained absent, my lord. In several occasions, my lord, the honorable court, my lord, imposed cost upon him, my lord. And even after imposing cost, my lord, he remained absent, my lord. Only to, my lord, harass the, my lord, petitioner wife, my lord, because he has married, my lord, and second time, he has been blessed with a child also, my lord. And he knows that, my lord, he will not take back the petitioner, my lord, the wife. Even then, he has been lingering the proceeding, my lord. In this case also, my lord, on 23, my lord, his cross-examination closed, my lord. And after more than 3 months, my lord, he has approached this honorable court, my lord. 4 times after the impugned order, my lord, 4 times he has taken time in the trial court, my lord. After taking 4 times in the trial court, my lord, he approached this honorable court, my lord. This is also, my lord, shows he, my lord, delaying the tactics, my lord, to proceeding, my lord, in the lower court, my lord. I have supplied the original copies, my lord, lordship, original copy of the whole order sheet, my lord. Your lordship may go, my lord. That 25 times he took time in the proceedings, my lord. And my lord, there is no bar, my lord, as per, my lord, this order 17 rule 1, my lord. The trial court has the, my lord, jurisdiction, my lord, has the to exercise the power, my lord, under 17 rule, my lord, 1, my lord. He can reject, my lord, the prayer of adjournment, my lord, based on his conduct, my lord. The respondent husband's conduct for the last 5 years, my lord, the honorable court, my lord, it is also evident from the impugned order, my lord, that on 4/5 the petitioner wife, my lord, submitted the examination in chief, my lord. And till on March, my lord, he did not receive the copies of the, my lord, from 4th of May 2023 to March 24, he did not receive the copies of the examination of chief, my lord. That also, my lord, reflected in the order sheet, my lord, that his intention is, my lord, only to delay the proceedings, my lord. Intentionally, he did not receive the copies of the examination chief, my lord. So 2 times he submitted the adjournment prayer without any, my lord, medical document, my lord. On medical ground, my lord, he has prayed for medical ground, but without submitting any medical documents, my lord. So, my lord, there is no wrong on the part of the, my lord, the learned trial court in exercising jurisdiction, my lord, by rejecting the closure of his, my lord, right to cross-examine the, my lord, only 2 witnesses, my lord, the petitioner wife and her mother, my lord, aged mother, my lord. So, my lord, this honorable court, my lord, may not interfere, my lord, under 227, my lord, because there is no, my lord, jurisdictional error on the part of the, my lord, learned trial court in rejecting the petition, my lord. And your lordship may go to the order sheets, my lord, original order sheets, my lord, I submitted, my lord, which reflects his, my lord, conduct, my lord, in several occasions, my lord. 25 times he have taken the, my lord, the so, my lord, from 27 to 19, from 27 to 19, my lord, he has been taken time, my lord, 27 to 19, 25, 3, 19, my lord, 11, 11, 19. And I have submitted a judgment, my lord, honorable apex court, my lord, 2022-1 civil CC 176, my lord.
Right, whether he is remaining absent before the trial court cause any hindrance in proceeding with the case?
In some occasions, my lord, in fact, my lord, in this
he may not remain present, but his counsel was present.
Yes, amicus curiae in some occasions present. In
Yes.
this case, my lord, for cross-examination, my lord, his presence was not required, my lord.
Yes.
His presence was not required, but on the ground of his absence, the cross-examination was not done, my lord. For cross-examination, his presence was not required, my lord. If he had to cross-examine the witnesses, my lord, it was the duty of the counsel, my lord. And this the Honorable Supreme Court, my lord, in 2021 Civil CC, my lord, in Ishwarlal Mali Rathur case, my lord, it is specifically mentioned, my lord, that this provision is, my lord, after amendment, my lord, for this to reduce the practice of adjournment, my lord. Your lordship will find in the whole judgment, my lord, the this my lord practice, my lord, discussed Honorable Supreme Court, my lord, and particularly in paragraph 5.5, my lord, your lordship may give me one of the paragraph 5.5, my lord. May I read, my lord, one of the paragraph, my lord. In the whole judgment, this is discussed, my lord. Today, the judiciary and the justice delivery system is facing acute problem of delay, which ultimately affects the right of the litigants to access to justice and the speedy trials. Areas are mounting because of such delay and dilatory tactics and asking repeated adjournments by the advocates and mechanically and in routine manner granted by the courts. It cannot be disputed that due to delay in access of justice and not getting the timely justice, it may shaken the trust and confidence of the litigants in the justice delivery system. Many a times the task of adjournments is used to kill justice. Repeated adjournments break the back of the litigants. The courts are enjoined upon to perform their duties with the object of strengthening the confidence of common men in the institution entrusted with the administration of the justice. Any effort which weakens the system and shake the faith of the common man in the justice dispensation system has to be discouraged. Therefore, the court shall not grant the adjournment in routine manner and mechanically and shall not be a party of the cause to delay the dispensing of justice. Courts have to be diligent and take timely action in order to usher in sufficient efficient justice dispensation system and maintain faith in rule of law. We are also aware of that whenever trial courts refuse to grant unnecessary adjournments, many a times they are accused of being strict and they may face displeasure of the bar. However, the judicial officer shall not worry about that. If his conscience is clear and that judicial officers has to bear in mind his duties to be litigants, the litigants who are before the courts and who have come for justice and for whom courts are meant, and all efforts shall be made by the courts to provide timely justice to the litigants. Take an example of present case, suit was for eviction. Many a times suits are filed for eviction on the ground of bona fide requirement of the landlord. If plaintiff who seeks eviction decree on the ground of personal bona fide requirement is not getting the timely justice and ultimately gets decree after 10 to 15 years, at times cause for getting the eviction decree on the ground of personal bona fide requirements may be defeated. The resultant effect would be that such litigant would also lose confidence in the justice delivery system, and instead of filing civil suit and following the law, he may adopt the other mode which has no backing of law and ultimately it affects the rule of law. Therefore, the court shall be very slow in granting adjournments, and as observed herein above, they shall not grant repeated adjournments in routine manner. Time has now come to change the work culture and get out of the adjournment culture, so the confidence and trust put by the litigants in the justice delivery system is not shaken and the rule of law is maintained. In view of the above and for the reasons stated above, and considering the fact that the present case 10 times adjournments were given between 2015 to 19 and twice the orders were passed granting time for cross-examination as last chance, and then two at one point of time even a cost was also imposed, and even thereafter also when lastly High Court passed an order with extending the time, it was specifically mentioned that no further time shall be extended and or granted. Still the petitioner defendant never availed the liberty and the grace shown. In fact, it can be said that the petitioner defendant misused the liberty and the grace shown by the court. It is reported that as such, now even the main suit has been disposed of. In view of the above circumstances, the present SLP deserves to be dismissed. So, my lord, this is a divorce petition, my lord. The petitioner wife is 35 years of age, my lord, and still she is in marriageable age, my lord. And by delaying, my lord, she is losing her, my lord, valuable time, my lord. that, and there is no chance of, my lord, reconciliation or getting back to the husbands, my lord, who has already married, my lord, to another wife, my lord. And my lord, in the
But
affidavit-
fair opportunity has to be given to him also to establish his case.
Yes, my lord, but my lord, the honorable court, my lord, by by observing his conduct.
Don't you feel that one chance is to be given to him? Last chance, last opportunity is to be given to him.
Yes, my lord, that may be, my lord, your honorable court allow, my lord, but my humble prayer on behalf of my lord, the petitioner wife is that, my lord, that this honorable court, my lord, may allow the date by giving him, my lord, that on the same day, my lord, he may cross-examine the only two witnesses.
Yes, madam.
Both of them the same day, my lord. And my lord, he will again delay, my lord, in producing his evidence, my lord. So, my lord, within a specified period, my lord, that he may, my lord, adduce his evidences, my lord. Otherwise, my lord, for the 5 years, he is, my lord, delaying the proceedings, my lord. That my prayer, my lord, that a date may be fixed and giving the date for examining two witnesses on the same day, and also, my lord, to adduce his evidence within a specified period.
Evidence not same day possible, Lordship. Cross examination is possible in same day. But for my examination, see, for another date is required, Lordship, for defense witness.
Yes, my lord, another date may be
Yes.
fixed, my lord.
But
So
for
that-
cross examination, one day that is possible, but both are not possible in one day.
And my lord, for disposal of the.
Lord
proceeding-
Ms. P. Bhattacharya, learned counsel for the petitioner, and Mr. M.J. Kadir, learned counsel for the respondent. In this petition under Article 227 of the Constitution of India, the petitioner, Mohammad Azad Khan, naam to likhwa na bhai. The petitioner has put to challenge the correctness or otherwise of the order dated 28/3/2024 passed by the learned Principal Judge Family Court, Kasar Silsor, in FC within bracket civil case number 9 of 2019. It is to be noted here that by MP order dated so and so, the learned Principal Judge Family Court has closed the evidence of PW1 and PW2 without cross-examination, rejecting the pair of the petitioner for adjournment of the case. Ms. Bhattacharya, learned counsel for the applicant on the petitioner submits that only on one occasion the petitioner could not remain present in the court, and
Page 48. Lordship. 8.
1 for
48.
and that he is ready to cross-examine the witnesses of the respondent, and therefore Ms. Bhattacharya submits that one chance may be given to him to cross-examine the PW1 and 2. PW1 and 2. On the other hand, Mr. Kadir, learned counsel for the respondent, vehemently opposed the petition on the ground that the conduct of the petitioner is not at all satisfactory. Referring to the orders of the proceeding before the learned Principal Judge Family Court, Mr. Kadir, pointed out that on as many as 25 dates, the petitioner remain absent, and he has been delaying the proceeding before the learned Principal Judge Family Court. Mr. Mr. Kadir further referred to a decision of Honorable Supreme Court in the case of Ishwar Lal Mali Rathur versus Gopal and others, reported in 2021 9 SCR 35. Permits that unnecessary adjournment should not be granted by the learned by the learned trial courts. Which in fact kill the justice, and arrears are mounting because of such delay and dilatory practice, and asking repeated adjournment by the advocates and mechanically and in routine manner granting the same by the courts. And therefore, Mr. Kadir, learned counsel for the respondent, has contended to dismiss the petition. But having heard the submission of learned advocates of both the parties, I have carefully gone through the petition and the documents placed in record, and also gone through the decision of Honorable Supreme Court in the case of Ishwar Lal Mali Rathur, Bagat Supra. And also the dates and also the orders passed by the learned Principal Judge Family Court on various dates since 2019. Since 27 to 2019 till 1/7/2024. There is no manner of doubt that some lapses are there on the part of the petitioner, but it is now well settled that right to fair trial is a fundamental right, which includes giving up proper opportunity to both the parties to establish their cases, be it civil or in criminal. In the instant case, the learned Principal Judge Family Court has closed the evidence of PW1 and PW2. And unless the petitioner is allowed to cross-examine those two witnesses, he will be deprived of establishing his case before the learned Principal Judge Family Court. And in that view of the matter, this court is of the view that one chance has to be given to the petitioner to cross-examine the witnesses, that is PW1 and 2, before the learned Principal Judge Family Court. Under the above mentioned facts and circumstances, this court is inclined to allow this petition. The order dated above, the learned Principal Judge Family Court is directed only one opportunity to the petitioner to cross-examine the PW1 and 2, and thereafter proceed to hear and dispose of the case in accordance with law. In terms of above this CRP instance disposal.
My lord, my case, prayer, my lord, that within a specific period, my lord, the remaining part may be concluded, my lord.
Pardon?
Trial, my lord, disposal of the divorce petition, my lord. Yeah, within
So that kind of direction cannot be given. Have you ever of the decision of Supreme Court in
yes.
Allahabad High Court Bar Association. This court cannot issue direction.
Obliged.
Standing item 28. Have been personal service. Justice service has been made on dated 30/7/2024.
Okay. Heard, Mr. You please, good name. BK Sharma, learned senior counsel designated. Learned senior counsel assisted by Miss. Your good name.
P. Sharma.
Your name.
Sharma.
Learned counsel for the appellant. Office note dated 13/8/2024 indicates that an affidavit has been filed by the learned counsel for the appellant in respect of justice service upon the sole respondent. And the same is placed at flag A. Perusal of the affidavit dated 5th of August 2024 indicates that notice upon the sole respondent was served. And the sole respondent received the same by putting his signature. But none appears on his behalf. As such, the service completed here in this appeal and receives at least the matter for hearing in usual course. Whether a substantial question of law were framed here? Framed.
At page 11.
Right. Okay, rest we will fix it for hearing in usual course.
31.
Ma'am, out of total 6 respondents, only respondent number 1 has made appearance. As per office note dated 16/8/2024. So I will take fresh steps upon respondent number 2 to 6.
My pleasure, Lordship. My pleasure, Lordship. As per court's order dated 5 January 2024, Lordship, they have not taken any steps till today, Lordship. And I am appearing here for principal respondents number 1, Lordship, and I am the plaintiff of title suit number 1, 2024, Lordship. So performer respondents service is not very required, Lordship. It's not necessary, one Lordship, and they have filed this petition for impleadment, Lordship. So matter may be fixed for admission hearing, Lordship.
After receiving notice by my learned friend, he is appearing.
How many respondents are there?
Total 6 respondents are there.
Pardon?
6.
6.
Lordship.
So notice was served only upon one and
One.
he appeared on his behalf.
Yeah.
The remaining respondents?
I will take first.
They're the
Pardon?
performer respondents, Lordship.
Pardon?
They are the performer respondents, Lordship.
They are original dependent to the suit. So their presence is
Their presence is not necessary, Lordship. I am the plaintiff, Lordship, of this title suit, Lordship. And they have filed for impediment, Lordship. So matter may be listed for admission hearing, Lordship.
Yes?
Admission hearing are not necessary, Lordship.
We have to strike up their name. Then
Kindly
What is your
give me an
submission?
Opportunity to take fresh steps. Lordship.
pardon?
Kindly give me an opportunity to take fresh steps.
Press is there.
Lordship.
But the proceeding is state.
Yes,
Yes,
Lordship.
Heard, Mr.
R. Ali.
Learned counsel for the petitioner and Mr.
MS Mondal.
MS.
Mondal.
Learned counsel for the respondent number 1. Office note dated 16/8/2024 indicates that no step has been taken by the petitioner upon performer respondents. The learned counsel for the petitioner submits that he may be granted an opportunity to serve notice upon the respondents, performer respondents. There is accordingly allowed. Step be taken within a period of two working days from today by registered post and also by usual process.
Interim
With
order
80.
pass earlier may be continued. Interim order pass earlier may be continued.
List the matter after 4 weeks. Till then, interim order dated 5/1/2024 shall continue.
32.
Lordship, for the time being, my senior is in the another court. So kindly the matter to us.
33.
Lordship, 32 is my case. 32.
32.
This is my case. I have taken dusty service, Lordship, in this case. Upon the respondent 2 and 5.
32 is your matter.
Yes, Lordship.
And what is your matter? What is the number?
We also the 32, sir, Lordship.
32.
You are respondent, I think respondent.
Is respondent.
Maybe. And the appellate.
So service completed.
Affidavit was taken upon respondent 2 and 5 first. So I think also respondent number, Zola is also complete, Lordship, but did not appear. Zola check, Lordship, is performer dependent, maybe take out. Then respondent is Lordship, Rafiqul Islam and Taijul Islam. Others are performer dependent. Respondent Lordship, Rafiqul Islam and Taijul Islam, Lordship. Other are performer dependent. Step complete, Lordship.
So yes, you are appearing for respondents.
Yes, my lord.
Respondent number?
Yes, sir.
My case.
Hmm?
Sullivan is the plan.
Lordship, whatever actually Mr. A.R. Sidar Lordship is sent to him. He is leading
Who is your senior?
A.R. Sidar Lordship.
Let him come.
No, Lordship, A.R. Sidar is in our case, Lord, petitioner Lordship, appellant.
Pardon?
Appellant Lordship.
Let Mr. Sigdar come. Wait for some time.
It's not good.
Madam, can you please?
Lordship.
My lord, in this case, my lord, we took steps and they have appeared, my lord. And my lord, here is a delay of 431 days in preparing the second appeal. Mainly because he's a driver and because of the COVID period, he was unable to ply his vehicle and so he could not arrange money, my lord. Financial hardship, my lord.
So this is for condonation of delay.
Delay, yes.
For how many days?
431 days delay, my lord.
431 days. Yes, any objection?
Lords, one week time may be granted for filing objection, your lordship.
Objection. Heard Mr. Aishwarya, learned counsel for the applicant, and Mr.
MD A Rahman.
MDK Rahman, learned counsel for the respondent. Mr. Rahman submits that he may be granted 1 week time to file objection in this petition. There is accordingly allowed. Recessal is the matter after 1 week.
My lord, can it be a date may be fixed because the education proceedings is going on.
On 2nd September.
2nd September. Obliged.
24.
Lordship, in this matter, Lordship, respondent number 1, 2, 3 service report is complete, Lord. 1 and 3, sorry, Lord.
1 and
1 and 3
completed.
completed, Lord.
And how many respondents are there?
7, Lord.
7.
Others,
And,
Lordship,
in respect of remaining 5,
respondent number, Lordship, 4 to 7, Lordship. Twice I had taken the steps, but the respondents are avoiding. So I may be allowed to do the paper publication.
paper publication.
And Lordship, this respondent number 2, it has a typographical mistake because it should be a stuck of Lordship.
Respondent number 2.
2, Lordship.
Okay.
In the plaint, there is no such respondent, dependent.
Heard Mr. S.P. Roy, learned counsel for the appellant, and Mr.
Can Borwa, Lordship.
S.
I
Can
am
Borwa.
appearing in person, Lordship. That's.
Acha, learned applicant in person, and Mr.
Can Borwa, Lordship.
learned counsel for the respondent number 1 and 3.
1 and
1 and 3. Mr. Roy, learned petitioner in person, submits that respondent number 2 is incorrectly pleaded in this petition, and as such his name may be struck off. Here is accordingly allowed. Mr. Roy further submits that service of notice in respect of the remaining
4 to 7, Lord.
remaining respondents 4 to 7 have been avoiding service of notice, and as such a prayer is being made to allow him to cause service of notice upon them by substituted mode by paper publication. There is accordingly allowed after publishing the notice. But in the cause list, name of some advocate has been reflected, representing 567.
5, 6, 7, Lordship. Earlier, yes, remaining respondent Lordship to appear MD Chaudhary.
No, one of the 1 to 3.
1 to 3.
Respondent number Miss P. Zindal.
Substituted legal yes have therefore respondent number 3 Lordship.
Respondent number 3.
And they have appeared.
Acha. But in the cause list, it is reflected that respondent number 5, 6, 7, 8, 9.
It is not correct, Lordship.
So after paper publication, the learned council shall file an affidavit along with the respective papers before the court within 4 weeks from today.
Lordship, yeah. One of the problem, Lordship, without interim, petitioner has constructed the house in Suitland, Lordship.
I could not follow you. Volume to compensate.
My learned friend has submitted that without taking the consent of the landlord. I am doing some construction.
Without interim, Lordship, the petitioner has.
That is not correct, Lordship. They have not filed any.
Lordship. I will objection your
I am the secretary of the trust, Lordship. That's why I am appearing in person. It is a trust property.
Okay, after publication of the notice, you furnish the respective papers before this court with an affidavit. List the matter after 4 weeks.
Lord. Oblige.
Item 35.
It's a net appeal, Your Lordship. As per office on dated 16/8/24, Your Lordship, no service report or AD has been returned back, Your Lordship. But Your Lordship, there was a IA, Your Lordship, regarding condemnation, Your Lordship. That was also, in that case also, we took steps, Your Lordship, but they refused to accept the notice, Your Lordship. Thereafter, trustee service was done, Your Lordship. There also, they refused to accept, Your Lordship. And accordingly, the condemnation was allowed. And Your Lordship, now again, the notice being, there's a direction to take steps upon the respondent, Your Lordship. They are again refusing to take the notice, Your Lordship.
So where is the report?
Yes, Your Lordship.
Where is the report?
As per office on dated 16/8/24, Your Lordship. No AD or notice has been returned back, Your Lordship.
No, neither AD card nor unserved notice returned.
Yes, Your Lordship. But Your Lordship, my submission is that if there was an IA, Your Lordship, in that IA also, that was a regarding condemnation of delay, Your Lordship. In that IA, they refused to accept the notice, Your Lordship.
You go for other modes then?
Then justice service may be given us.
Heard Miss S. Nazneen, learned counsel for the appellant. Office note dated 16/8/2024 indicates that LCR has not been received from the learned court below, and neither AD card nor unserved notice received back by the registry. Ms. Nazneen, learned counsel for the appellant, submits that she may be permitted to cause service of notice upon the sole respondent by Dastimut. Pair allowed. After effecting service upon the respondent, the learned counsel shall file an affidavit before this court. This is the matter after 4 weeks.
Oblige, Your Lordship.
36.
May it please your Lordship. Lordship, in this matter, the engaged counsel is on legs in another court, court number 1. Lordship may kindly pass out the matter for time being.
As agreed by learned advocates of both the parties. Any objection? The case is then adjourned for the day.
37.
Interim order that may be continued.
Time being.
Time being
or adjournment?
I prayed for time being, Lordship. Today itself.
Okay. Okay.
Oblige.
37.
Wait, resolve. My lord, in this matter, my lord, we have taken steps upon all the respondents, but perhaps, my lord, these steps upon respondent number 1 to 7 and 16 have returned answered, my lord.
Heard Mr. S. Das, learned counsel for the petitioner, and Mr. B.J. Mukherjee, learned counsel for the respondent number
8 to 15 and 17.
8,
8 to 15 and 17.
8 to 15, and 17. Office note dated 16/8/2024 indicates that neither AD card nor unserved notice in respect of respondent number 1 to 7 and 16 received back by the registry. What to do?
My lord, we can
Await service report, or you will take fresh step?
take fresh steps.
Fresh step. Mr. Das, learned counsel for the petitioner, submits that he will take fresh step upon respondent number 1 to 7 and respondent number 1 to 7 and 16. Here is allowed to be taken by registered post with AD and also by usual process within a week from today.
My lord, there is another prayer, my lord. A scan copy of a record, my lord, is to be called for, my lord. If your lordship will kindly see the cost title, my lord, page number 2. The record of title suit, number 8 of 2023. That will have to be called for.
Record of title suit number
8 of 2023.
Was there any order? No.
Yes, yes. Oh, no. On the last date, no order was made regarding calling for the records, my lord, but invariably, my lord, records.
Mr. Das, learned counsel for the petitioner, submits that in order to dispose of this petition, the record of title suit number 08 of 2022 is required, and therefore it is contended to pass
23, ma'am.
necessary order in this regard. Accordingly, it is provided that registry shall call for the scan copy of the record of title suit number 8 of 2022.
My lord, it will be 2023. 8 of 2023.
But it is mentioned in the cost title
My
as
lord, there is one mistake, but otherwise, my lord, the impugn order also suggests that, my lord, the actual number is 2023, my lord. We have included.
no,
at the
you
pair
file
also.
you file petition for correction of this. You follow the proper procedure.
My lord. Hello.
We'll call the record only after correction.
Then, my lord, will fix a short date next week, my lord. We will correct it by this.
Registry shall release the matter after 1 week.
My lord. Hello.
38.
So Lordship, I please to pay office note dated 16/8. Out of 7 respondent, 1, 2, and 3 has appeared. And against respondent of 4, 5, and 7, we have a published notice in newspaper. And as far as respondent number 6 is concerned, registered notice sent to him is not returned. So presumption may be taken against him.
How you have taken step?
By registered post against 4, 5, 6, and 7.
So where is the document to show that you have taken step by registered post?
Office note dated 15/7 will be produced. Will be seen. Office note dated 15/7/2024.
No, without the receipt, can we draw such a presumption?
My lord, we have sent by the register post and it is not returned against the respondent number 6. We have sent it by register post. And as far as 4, 5 and 7.
So
we have-
await for some time.
My lord, I guess they'll have to take fresh steps, my lord. It has not returned.
No, no.
As regards respondent number 6 is.
6 is concerned. It is not returned. And we have sent it by registered note.
4, 5 and 7, they have filed an affidavit, dusty
Affidavit.
affidavit stating
No,
that they have
not
taken.
a dusty, by
Sorry,
paper
ma'am.
publication.
Paper publication.
4, 5 and 7.
Heard Mr. A. Parvez, learned counsel for the petitioner, and Mr.
A Bhatra for respondent number 121.
Respondent number 1, 2, and 3. Mr. Parvez, learned counsel for the petitioner, submits that an affidavit pertaining to paper publication in respect of service of notice upon respondent number 4, 5, and 6.
7.
4, 5, 6, and 7 has been submitted before this court. Then it appears that notice upon the said respondents number 4, 5, and 4, 5, 6, and 7 deemed to have been served, but they
My lord, only 4, 5 and 7. not
unrepresented
6.
today.
Only 4, 5 and 7, not 6.
A registered note, let it not
But
return back.
in the earlier order, it is reflected as 6 also. Okay. Office note dated 16/8/2024 also indicates that neither AD card nor unserved notice in respect of respondent number 6 received by the section. So leaves the matter after 1 week awaiting service report upon respondent number 6.
Your lordship,
In the meantime, you can track the in the website of the postal
Yes.
department. Raise this at the consignment and put up an up-to-date note before this court on next day.
39.
May I please, your lordship?
Hmm.
Your lordship, as per office note dated 16/7/24, your lordship, unserved notice has been received for pro forma respondent number 5, 6, 7, and 8B. And in respect of respondent pro forma respondent number 8A, 8C, and 8F, your lordship, neither ED nor unserved notice has been received, your lordship.
So you want to take fresh step?
Your lordship, they did not appear in the trial court also, your lordship. So I think their name maybe can be striked up, your lordship.
I have already filed our objection
Hmm.
with respect to main respondents, 1 to 4.
1, 2, 3, and 4.
Yes.
Okay. Heard Mr. Pal.
As for your lordship.
As Paul, learned counsel for the applicant, and Mr. S.K. Ghosh, learned counsel for the respondent number 1, 2, 3, and 4. Office note dated 16/7/2024 indicates that service report, unserved notice upon the pro forma respondents number 5, 6, 7, and 8B returned unserved with a report.
5 has left address, 6 left address, and for 7, no such address.
It is stated that respondent number 5 left address RTS, and respondent number 6 left RTS. The left address RTS. Respondent number 7, no such addressee. Respondent number 8B, addressee expired. Mr. Paul, learned counsel for the applicant, submits that these performer respondents have never appeared before the trial court also, and as such, their name may be struck from the array of this application, where is accordingly allowed the name of respondent number 5, 6, 7, and 8B be struck off from the array of this petition. Mr. Ghosh, learned counsel for the respondent number 1, 2, 3, and 4 submits that he has already filed objection in this application. So when to be listed?
My lord, at the cost and risks of the.
Pardon?
At the cost and risks of the appellant, it may be struck. That
Okay,
part.
at the risk of the applicant. So when to be listed?
My lord, otherwise, I have already filed our.
Are you ready?
No, not today, your lordship. Actually, SY was about to appear, your lordship.
You are not ready?
No, your actually.
After 1 week?
Your lordship, can it be in the second week of September, your lordship, because senior SYC will be going out of
Okay.
station for treatment, your lordship.
Okay, as agreed by learned advocates of both the parties, races and list the matter in the second week of September.
Oblige, your lordship.
Item 40.
May I please, your lordship, as per office note dated 18/6/24, lordship, respondent number 4 appeared, lordship, by filing Wakalatnama and notice served upon respondent number 1, lordship, and no ID card or answer notice of respondent number 2 and 3 has been arrived, lordship. So I will await for service report, lordship.
Pardon?
Respondent number 2 and 3. I will await for service report, respondent number 2 and 3, lordship.
Respondent number 2 and 3.
2 and 3, lordship.
Heard me, sir?
AR Das.
Learned counsel for the applicant and Mr.
J.
Kolita.
J. Kolita.
Learned counsel for the respondent number
4.
4.
4.
4. Office note dated 18/6/2024 indicates that AD card in neither AD card nor unserved notice in respect of respondent number 2 and 3 received by the section. So list the matter after 2 weeks, awaiting service report upon respondent number 2 and 3. But in respect of respondent number 1, it was received by one Lilima Gogoi. And it is not known what is her relation with the respondent number 1. You say you examined the matter, you inform the court on next date. List the matter after weeks.
Much of it.
41.
Yes.
Lordship, against the judgment of reversion, my lord, second appeal, however, there is a delay of 222 days, my lord. I don't know the issue.
This IS for condonation of delay.
Yes,
Heard, Mr. Your good name?
GJ Soiga, ma'am.
PJ.
G. Gautam. Z.
Z. Learned counsel for the applicant. This application under Section 5 of the Limitation Act is preferred by applicant Oren Nomodas for condonation of delay. How many days?
222 days, my lord, as per the office, my lord. I have put it 224, the prayer portion. Case 8.
For condonation of delay of 222 days in preferring connected appeal against the judgment and decree dated 29/4/2023 passed by the learned civil judge senior division Sirang in title appeal number 8 of 2022. Let notice be issued to the respondent returnable in 4 weeks, step be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks.
Okay.
42.
Meet reserve lordship. Sir, this is an RSA, my lord, regular second appeal, my lord. Service is completed, my lord.
This IA is for?
IA is for stay of the execution, my lord. Substantial question of law already framed, my lord, on the last occasion, my lord. And we have taken steps. Service is perhaps completed, my lord.
So service completed?
Yes. And my lord, the
My lord,
records-
I appear for during that, but at present I only filed Oglala for one respondent.
Hmm.
Others I will file.
How many respondents are there?
5 respondents.
Five.
8.
Five.
5.
Only one for I file and others I will wait to get the Oglala.
You are awaiting.
Waiting.
So after warning then?
And my lord, records will also have to be called for, my lord.
Record.
Yes. Second appeal has been admitted, but for some reason.
Let the record come,
will
my
not
lord.
call for,
In
my
the meantime, I will file Oglala also.
Hmm.
And the entire matter may be disposable. Simple point is involved here, my lord.
Okay.
After 3 weeks,
Heard
let the matter come,
Mr.
my lord.
S. Das, learned counsel for the applicant, and Mr.
Yeah, my lord.
J. Ahmed, learned counsel for the respondent number 1. Respondent opposite party number 1.
I will file Oglala for other also. I have been instructed.
This application, Mr. Ahmed submits that he will be filing power in respect of respondent number 2, 3, 4, and 5 within a week from today, and granted him 1 week time period is accordingly allowed. But this application under section under order 41, rule 5 reduced section 151 of the CPC, referred by the applicant for staying operation of the impugned judgment and decree dated 22/4/2021, passed by the Munship number 1, learned. No, presently, civil judge within Beckett Junior Division, Barpeta, entitled suit number 24 of 2015, which was affirmed by the judgment and decree dated 19/2/2024, passed by the learned civil judge within Beckett Senior Division, Barpeta, dismissing the title appeal number 11 of 2021, preferred by the appellant, struck defendants. Mr. Das submits that the connected second appeal has already been admitted after framing substantial question of law. But the record of the title appeal number 11 of 2021 and the title suit number 24 of 2015 from the learned courts below have not yet been called for. And therefore, Mr. Das contended to call for the records from the learned courts below. It is provided that recess shall call for the records of the aforementioned cases from the learned courts below. This is the matter after 1 week,
3 weeks.
3 weeks.
Let the record come also.
Only it is 3 weeks, my lord, till the returnable date. Only the operation of these impugned judgments.
My
will
lord,
take-
execution is not filed.
Execution is pending on. Execution, my instruction is that execution already filed against the judgment of the trial court. So it is
Execution
pending.
file.
Yes.
Provide a number.
Yes, I can provide.
So let after 2 weeks come and on that day. In the meantime, nothing will happen.
No, 1 week. Not 2 week, 1 week.
Well,
This is the matter after 1 week.
43.
hello.
Service is complete.
Service completed.
Well, next week, better.
Heard, Mr.
Please, Ekya.
Learned counsel for the appellant. Office note dated 7/8/2024 indicates that service upon sole respondent is completed. But respondent number, but the sole respondent remain unrepresented today. Justice shall list the matter in usual course for hearing. List the matter. No, not
My
necessary.
lord, with due respect,
In usual course.
my lord, they have filed a money execution case and the next date is on 7/9/2024. So, my lord, before 7/9/2024, hearing matter, hearing may be taken.
No, ये तो notice दिया ना यार.
My lord, we have no stay also. Yes, my lord.
No, that's all right, but what about the IA?
That's why we have filed the Your Worship, because they have filed the money execution case. We have filed the IA for the stay of the money appeal and the
No,
punishment.
stay will be only depositing security. You have to deposit at least 50% of the amount
Let the matter maybe here next week.
next week.
Next week. For hearing.
Okay, in IA, as spread for by learned counsel for the applicant, SSL is the matter after 1 week, along with RSN number 70 of 2024.
44. May I please your lordship?
Yes.
One thing. Your lordship, can it be listed for hearing on that day? Then on that day, it will be considered appeal will be heard like
Which matter?
on 30th April, August,
IA.
matrimonial appeal. It is in hearing, a record has come, LCR has
My
come.
lord, though I must, I should not say, my lord, this IA probably, this IA is unwarranted, my lord. Rather, my lord, if she has an urgency, the appeal may be heard. I am there to argue any date subject to our convenience. Because in an IA, in an appeal filed by me, how can they make a prayer for stay of a proceeding which is not before your lordship?
That will be decided while hearing, your lordship. All the thing will be decided in one petition that time. So let it be fixed for hearing, not for orders.
No, today only the IA is listed.
Yes, your lordship.
So
But on
therefore, we cannot pass order in the matrimonial appeal. Next that we will pass order.
Much.
45.
Lordship, IA 24.
So heard, miss? Your good name?
S. Todi, Lordship.
Learned counsel for the applicant and Mr.
A Singh Lordship for the appellant.
For the
Appellant Lordship.
for the appellant. Stroke opposite party. This application, interlocutory application is preferred by the applicant for early hearing of RSA number
260.
260 of 2013. After hearing both the parties, here is allowed, receipt shall list the RSA on copy one. So do we fix a date?
Lordship, 10th of September, Lordship. 12th of September.
12 of September. In terms of this IA this will work.
Obliged, Lordship.
46.
Please, your lordship. This I is for condonation of delay of 21st of March. So notice may be issued at this time.
Heard, Mr.
Harsha.
Learned counsel for the applicant. This application under section 5 of the Limitation Act is preferred by the applicant, the Oriental Insurance Company Limited, for condonation of delay of 21 days in preferring appeal against the judgment and award dated 28/3/2024, passed by the learned member MSCT, Motor Accident Claim Tribunal, Bazali Patsala, MSC case number 98 of 2019. Let notice be issued to the respondent, returnable in For weeks that be taken by registered post with ADN also by usual process. This is the matter after 4 weeks.
47. IA, your lordship, can you see page 15? Though it is not for confirmation of delay, but I'm just pointing out your lordship, can you see page 15? One page order, my lord.
How many days?
No, delay of
41
41
days.
days, but earlier, my lord, my purpose of showing this is, my lord, earlier we filed a writ petition. So writ petition order was there, that the order passed by the additional district judge, my lord, it will not, that is in regard to compensation, my lord. Your lordship knows under the National Highways Act, if there is dispute as regard payment of compensation, it can be referred to the district judge, principal civil court. So accordingly, the matter was referred to the district judge. District judge, without hearing the present appellant, who is in occupation of the land for last 20 years, this order was passed. So this order was stayed. So subsequently, the matter came before Honorable Justice Devashish Purwa, and he pointed out that it should have been a petition on the Article 227. I agree to that. So accordingly, I filed a 227 petition. Now, there is a delay, whether your lordship will issue notice, but as regard stay of the proceedings, whether I rely only on one judgment, that your lordship, during the paragraph 2.
No, today this IA is listed only.
Yeah, I understand.
So here we have to issue notice to the other side.
Notice, but regarding that stay petition can also be listed, madam. Your lordship may direct, because of that judgment, otherwise I would not have placed.
Stay petition, but without disposing of this IA and without registration of the other case.
See the judgment, paragraph 2. In some exceptional cases, it can be done. I leave it to your lord.
So is there any urgency?
Because my lord, this otherwise the amount will be, my lord, disposed of. Amount will be disbursed. Because I am one of the claimant. If your lordship kindly take into consideration the main case. Page 32. No, sorry, my lord.
You do one thing, we will issue notice at this stage.
Yes.
We'll fix a very short date. In the
Short date,
meantime, you
but
call
if
service
your
of notice,
lordship can-
thereafter we will see.
Can say that because if the amount is disbursed, my lord, then irreparable loss and injury will be caused to the petitioner.
Okay, you
I'll
file
get-
an application before the learned court below that a petition is pending before the High Court.
That
So
will
time
do.
being it may be
That
stayed.
will do, but your lordship will also consider stay petition.
But I am not in favor of
Not now. I'm saying
staying
because
the
of this
proceeding before condonation of delay.
My lord, your lordship will give me, my lord, your lordship will issue notice and also provide, my lord, will take justice.
Yes, all right, we can do that. Heard Mr. B. Didas, learned senior counsel assisted by Mr. So-and-so, learned counsel for the applicant. This application under section 5 of the Limitation Act is referred by the applicant, Sri Amit Kumar Bora, for condonation of delay of 41 days in preferring civil revision petition challenging the order dated 28/3/2024 passed by the learned additional district judge Jorhat in land acquisition reference number 30 of 2024 under section 3H within bracket 4 of the National Highway Act 1956. Let notice be issued to the respondents, returnable in 4 weeks or 2 weeks.
Yes, your lordship, my lord, have no difficulties. Your lordship may mention that earlier petitioner has filed a writ petition.
where this order
No,
was.
that will be considered at the time of hearing of this application. Definitely under section 14, you will get the benefit.
Section 14?
Limitation Act.
Yes, yes. No, that is there. I'm not worried about it. I'm worried about, my lord, in case, my lord, district judge, my lord, in view of the order.
No, you inform the learned court that a petition is pending before this
No,
court
it's,
and it is under consideration.
my lord, dusty.
Dusty service is also permitted. 2 weeks, 2 weeks,
2 weeks.
within 2 weeks. Dusty service is also permitted. List the matter after 2 weeks.
48.
Wait, this is a lordship here, service is complete, LCR also received. And by order dated 25/7/24, it was supposed to be listed for hearing. Again, they have listed for.
So,
order.
madam, this I is for what purpose?
Lordship, I have filed by the claimant and respondent number 1 to withdraw the amount
Acha,
deposited by
acha.
the.
But lordship, my humble submission will be lordship, it can be finally disposed of, both the appeal as well as the IA. Even next week, no issue, because we are going by what Rajesh versus Rajibir said, our appeal is based on that only. So whatever amount they are entitled to, they will get, but they might not be entitled to 4 lakhs lordship, because the doctor did not deduce evidence in the case. And court has given a disability amount. That is the
Lordship, the influence judgment was stay by this honorable court without the heart of the claimant. And for last 1 year, the stay order is enjoying. And stay order was granted with subject to deposition of the 4 lakhs rupees. And whenever the matter was admitted for final hearing and service was completed, the honorable court directed to file the application to withdraw the said amount lordship. That's why we have filed. If the generally lordship to disposal the MSC appeal to take time lordship. It will take time, then 4 lakhs rupees pending from 1 year lordship before the registry.
No, lordship, there is no such order that they will file a petitioner, because even before they appeared on the first day itself, the it was admitted and yes, you were not present when the
On the
order.
very first day on the motion day lordship, the stay order granted.
So, what are the grounds in the appeal?
Lordship, the grounds are that lordship, exhibit 19 lordship, which was a disability certificate, was not proved by its author. And against
No,
that,
no, madam, this strict proof of strict proof of documents are not required in the MSc cases.
no, lordship.
Because it is not a trial, it is an inquiry only.
Lordship, one more submission regarding this disability certificate. When the petitioner was present before the learned member, the learned member asked him to work in the courtroom and thereafter called for the report from the Joint Director Baksha, and report was called from the court by self on online mode lordship. That was reflected in the judgment lordship, and order was the report is there lordship. And other report, he was admitted before the Medical College Fakhruddin Ali Ahmed Borpeta, and report was called by the tribunal on its own motion, and report is collected by the tribunal. Then where is the incorrect regarding this disability and his medical certificate lordship?
Lordship, that's
So,
why hearing is needed, lordship. And
No,
Rajesh-
hearing is necessary, but we cannot give him undue preference
No,
because
no,
lot of
lordship,
matters are
I'm
there.
ready any day, lordship.
No, no,
In this-
no.
This case, I'm ready any day, lordship can hear.
And going by the statement, object and reason of the act,
Yes,
we have to disburse this amount.
lordship, but lordship, that had it been so, lordship, on the day it was admitted, the court would have passed an order that it will
No,
be. when
we do not know why that court refused to know whether there was any pair for disbursing the amount.
No, lordship.
Then now they have approached this court by filing this IA.
But are they entitled to the 4 lakhs rupees, lordship? That is what I am submitting, lordship. Otherwise, lordship can, they have, lordship spent, this medical expenditure also, it is high because I have checked the.
Lordship,
yeah,
this is not
lordship,
an ex
2
parte
lakh-
order.
2 lakh
In their
50.
present lordship, fully participated
This
by the insurance
4 lakhs
company.
is a 50% amount.
No, it is
It's
less than.
50%, Lordship. 8
Less than
lakhs
50%.
total
Let me finish,
amount.
Lordship, then I'll reply, Lordship.
Lordship, 8,29,000 is amount awarded by the tribunal with interest from the filing of the application. And they have participated fully in the tribunal. And this judgment was not part in ex parte, Lordship. Then why they are taking this advantage by staying there on the motion day, Lordship? And if you will pending for
Okay,
further
okay.
proceedings, then
Lordship,
what will be
already
the-
it is fixed
regarding
for
the interest
hearing,
of 4 lakhs,
Lordship.
Lordship?
Lordship will peruse order dated 25/7/24. When they appeared, that was the day, that was the second day. And we fixed the, yeah, we are ready, we said that
Matter
we are
was-
ready for hearing. It was fixed for hearing.
Lordship, last occasion,
Then
matter was
decide this
listed
higher.
only mentioned by
So
the.
that will be only
correspondent, Lordship.
usual course. That to be fixed by the registry. So
No, Lordship,
many
you
other
can say
matters
the
are
day.
pending.
Lordship, I'm ready because this case I'm ready for hearing. I think they are also
No,
ready.
maybe,
because-
but we are not ready
Okay. Okay. So
because some
Lordship,
other matters are also there.
yes, Lordship. Lordship, what I can concede to right now is, Lordship, they have spent medical expenditure of 2,56,980. Lordship can round that off and that amount can be released.
No, 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 no.
Then Lordship, if 4 lakhs rupees, Lordship, let them give a bond.
No,
Oh,
no, no,
yes,
Lordship,
they will
Lordship.
give a bond.
Yes.
Why should I? No, Lordship.
No, you give a bond.
Yes, let them give a bond because if we win, then they will have to return back. That's the, yes.
Lordship.
Heard,
no-
mister?
No, Lordship, petitioner will not submit.
Pardon?
Lordship, petitioner will not submit bond, Lordship. How will?
You submit a bond only
Okay,
because the appeal is yet to be disposed of.
Lordship, that's why they
Ah.
have submitted the deposited 4 lakhs.
No, you
One
submit
year
you
ago.
may withdraw it by filing a bond or not. It is your discretion. We will pass the order. But don't interfere at the time of dictation of the order.
Sorry, Lordship.
That is my humble request. Third, mister, your good name?
A. Hussain, Lordship. A. Hussain.
A. Hussain, learned counsel for the applicant, and Madam Party Mazumdar, learned counsel for the respondent, opposite party.
1.
This application, interlocutory application is preferred by the applicant, Sahidul Islam, for releasing the deposited amount of rupees 4 lakhs by the applicant, no, to the applicant, stroke claimant as deposited by the appellant Oriental Insurance Company Limited before the registry of this court. Pursuant to order dated 31/7/2023 passed in IA within bracket civil number 2131 of 2013
23.
arising out of MSC appeal number 290 of 2023 by this court. The learned counsel for the applicant submits that pursuant to order of this court in MSC appeal number 290 of 2023, the opposite party number one has deposited a sum of rupees 4 lakhs before the registry of this court, and the applicant may be permitted to withdraw the same from the registry of this court. Ms. does, however, oppose the petition and submits that the matter may be finally heard and disposed of. The submission of learned counsel for both the parties are taken note of. And considering the facts and circumstances on the record and also bearing in mind the statement, object and reason of the act, this court is inclined to allow this application. On executing a bond of equal amount, the amount of rupees 4 lakhs deposited with the registry of this court be released in favor of the applicant.
In the appeal, Lordship, appeal may be listed. for-
Appeal already order is
Already
there.
Order is there. Registry won't list, Lordship, if there is today a fresh order is not there.
Pardon?
If a fresh order today
No,
is not there, registry might not list it, Lordship, because already that order is.
No, it is already, order is there,
Yes.
list the matter for hearing on a date to be fixed by the registry.
Yes, yes.
Registry will fix the date. Oh, yeah.
Fine, Lordship. Obliged, Lordship.
49. My lord, item 47. What had happened, my lord had passed orders for notice and dusty. Actually, I'm appearing for the state of Assam, that is respondent 8. I was there, but then we have been served notice. And I'm appearing for respondent 8 for the state of Assam. My name is K.K. Bhattacharya. I was there, but I forgot to point it out.
Respondent number 7.
Respondent number 8.
8.
For the state of Assam.
Okay.
I'm K.K. Bhattacharya. I'm a designated advocate.
Okay.
49.
May it please your lordship. Lordship, this IA is for condonation of delay and there is a delay of 35 days.
Okay, same order, pardon. Third, Mr. S. Dotto, learned counsel for the applicant. This application under proviso, second proviso to section 173 of the MB Act. Read with section 5 of the Limitation Act is preferred for condoning the delay of 35 days in filing appeal against the judgment and award dated 19/3/2024 passed by the learned member, Motor Accident Claim Tribunal, Dhuburi, Guwahati. What is Dhuburi, Guwahati?
Oh, your lordship, there was a typographical error.
Typographical.
Guwahati Urdu had been not there, your lordship.
Deleted. Mr. Dotto, learned counsel for the applicant, submits that he may be permitted to file an IA for correcting the cause title of the IA civil number 2453 of 2024, where is allowed, list the matter after 1 week.
Much obliged.
Timing matter 32.
Sorry, my lord, in this case, my 2 sets of colleague appeared, my lord, and your lordship was in confused in passing the order, my lord. Here in this case,
You are for respondent number?
my lord, we are appellant.
You are for appellant.
Appellant, and
Okay.
there is an order for dosti service to respondent number, pro forma respondent number 2 and 5. That we have, my lord, served, and we have also filed an affidavit enclosing the report, service report of dosti service. Lordship will find in my affidavit, Zohiruddin, the pro forma respondent number 5, and Qasir Ali, the pro forma respondent number 2. They have served, they have been served the notice, my lord. So, my lord, so far dosti service we have complied, but one respondent, my lord, pro forma respondent number 3, sorry, 4, my lord, he was never contesting the case. Trial court as well as the first appellate court. So, my lord, he
No,
is,
where you have filed the affidavit?
my lord, we have filed affidavit,
Yes.
my lord, on.
Okay, got it.
On, yes, my lord. But you will get the service report, annexer A and B. Zohiruddin is the pro forma respondent number 5, and Qasir Ali is the pro forma respondent number 2.
Okay, heard Mr. A.R. Sigdar, learned counsel for the applicant,
Appellant. Applicant.
stroke appellant. Mr. Sigdar submits that service upon respondent number 2 and 5 is effected by dusty mode, and an affidavit to that effect has been submitted before this court.
So far 3, some advocate appeared, my lord. Pro forma respondent number 3. So 3 has appeared. Only 4 remain. Well, you were never.
It appears that notice upon respondent number 2 and 5 has been served. But this shows us not to, no, but they remain unrepresented today. Mr. Sikdar submits that
Someone has appeared on behalf of 3, madam. Performer respondent 3.
that an advocate has appeared on behalf of respondent number 3. But today, none appears for him. So service completed.
My lord.
Mr. Sikdar submits that service in this application stands completed, and as such the matter may be listed for hearing. Where allowed, recessal list the matter on when after 1 week?
My lord.
After 1 week.
My lord, it is on the condonation matter.
Yes.
Condonation petition.
Yes.
Pending item 36.
Deep lovely.
I'm appearing on behalf of Mr. Aki Gupta, my lord. Respondent has filed a affidavit in opposition, my lord, 17-8, my lord. I need to file my reply. Personal fixes the matter for admission. In the meantime, I'll file my reply, my lord.
Transfer from which place to which place?
Lord, from Guwahati to Dibrugarh,
Guwahati to Dibrugarh.
my lordship.
You are for the
I'm for the respondent husband,
respondent husband.
my lordship.
Husband is staying at which place? Guwahati.
Guwahati, my lord.
And the petitioner is staying at Dibrugarh.
Dibrugarh, my lord. Otherwise, they have their own house also at Guwahati. But my lord, this is a matrimonial dispute, my lord. And at the very inception, my lord, we try for an amicable settlement in disputes arising out of, my lord, marriages. In this particular case, my lord, a settlement was already arrived at by both the parties. An amount was also fixed, my lord, that is 14 lakhs. Out of that, 7 lakhs has already been paid by the husband to the wife, my lord. But only because, my lord, this matter, because of, my lord, lockdown imposed, my lord, for the coronavirus and all those, my lord, issues, finality cannot be arrived, my lord. So, my lord, and this, my lord, the proceeding, that filing of a divorce.
Learned counsel for the applicant. For the petitioner to obtain instruction in respect of amicable settlement of the dispute between the parties.
For hearing item
Okay.
50.
My lord, there's an interim order, my lord, that may be continued.
Pardon?
Interim order is there, my lord, that may be continued.
Till then, interim order passed earlier shall continue.
Deeply obliged.
Highly obliged.
Please read that. Lordship, this is for enhancement of compensation, lordship. And here.
So what is the ground for enhancement?
Ground is the income, lordship. Income is taken 4,000 monthly, lordship. And this claimant was earning rupees 8,000. So as per Syed Sadiq, where there is in the concrete proof that it should be 6,500.
What was the profession?
What in lordship?
What was the profession?
No, profession was, he was.
This is a death case or injury case?
Injury case, lordship.
Injury. So what was the avocation of the injured?
Cultivator, lordship. Cultivator. Cultivator.
Cultivator.
Yes.
Acha. The tribunal has assessed his income as
4,000, lordship.
4,000. So what wrong with the tribunal's order? It was in the year 2016.
Yes, lordship.
Hmm.
So minimum wages act itself was 7,000, lordship.
As per?
7,300. As per minimum wages act, lordship.
Minimum wages act.
But Syed Sadiq.
So maybe, but he is a cultivator.
Yes, lordship. When there is no concrete proof, lordship, regarding evocation, etc., then the Syed Sadiq judgment, Honorable Supreme Court said that it can be 6,500, lordship. Or other
So
court-
whether that minimum wages notification of the government will be applicable to the cultivators.
Yes, Lordship. This compensation it is applicable, Honorable Guwahati High Court also and as per other courts also.
No, is there any judgment of Supreme Court in that regard?
No, our Guwahati High Court judgment.
Maybe you saw the judgment of Supreme Court, if any.
Supreme Court that is 6,500 is there, Lordship. So I am submit that may kindly be taken such Sadiq judgment, Lordship.
In respect of cultivators.
In respect of where there is no proof, concrete proof is not there, then that can be taken as 6,500. 2009 judgment.
Yes.
Lordship, claimant had admitted that he did not exhibit any document or
In respect of income.
and occupation, Lordship.
Hmm.
So at that point of time, in 2006.
But you have not disputed that he was a cultivator.
Yes, Lordship. But we had a question that have you exhibited any document? But he.
So what was the awarded amount?
The awarded amount was 3,75,705 crores.
Hmm.
And other things is there, Lordship, doctor was examined and disability was 70%, Lordship. Medical board certificate is there.
70% disability.
Disability.
Certificate was proved.
Yes, Lordship, it is proved by the doctor, Lordship, PW2.
So 70%, maybe there 70% disability was there.
Yes.
But what was the functional disability
Functional disability was.
assessed by the court?
Court has taken loss of earning 40% only, Lordship. Not functional
40%.
disability. Loss
So
of
what
earning
wrong with
40%.
the order? 40%, because this total disability and functional disability are different, no?
Yes, Lordship. But this functional disability sometimes it becomes higher, Lordship, again also. So if I humbly submit that if it is can be taken as 40 and 70 in between, that is if it is taken 60%, Lordship. That will be reasonable, I think.
That is your submission, but you have to show that how the tribunal is wrong in calculating the in assessing the compensation.
Lordship, court has not assigned any reason, Lordship, why it has taken 40% disability, Lordship.
Hmm. No, that has been laid down in the case of this Rajkumar Agarwala and Ajay Kumar.
Yes, Lordship, but that is Rajbir and Rajkumar, that will be 70% is proved, Lordship. I have discharged my disability.
So disability of which part of the body?
7 ribs are fractured, Lord. 7 ribs.
Ribs.
3rd rib to 9th rib, Lordship.
9 ribs.
Yes.
Fractured.
3rd to 9th, Lordship. 7 ribs fractured.
But there is no fracture of his limbs.
No, fracture is leg is not there, Lordship.
And hands are also not there.
But this ribs.
Maybe, but how it has affected your income?
Lordship, he cannot work.
Cannot?
Cannot work as a cultivator, Lordship. Because the rib is the main parts of the body, Lordship. Again, only not 1, 2 ribs.
No. What is the function of the ribs?
And there is spinal injury also, Lordship.
I don't think that the trial court has or this tribunal has committed any mistake. Anyway, you produce the judgment that in absence of any documentary proof,
yes, Lordship,
the minimum wages notification may be applied in case of cultivators also. Huh? You produce that notification?
And then in future prospects also not taken, Lordship.
Pardon?
Future prospects is also not taken, Lordship.
Future prospect.
Yes, Lordship. That should be 40%, Lordship, according to age of the.
According to?
Age of the victim, Lordship.
In case of?
In case of age, that is applied as per the age of the victim, Lordship.
What was the age of the victim at the time of occurrence?
38, Lordship.
38.
So 40 age, that should be 40%, Lordship.
So is it contemplated in the case of this Sorla Verma case?
Yes, Lordship. And Pranay
In respect of this farmers also?
Yes, Lordship.
Is it there?
Yes, Lordship.
Okay, you produce that judgment. Sorla Verma on next date.
Okay. Lordship will fix date, Lordship. Or I will give that.
As agreed by learned advocates of both sides, recess shall list the matter on
10 September.
10 September. 10 September.
10 September.
So as to enable Mr. Agarwal, learned counsel for the appellant, for producing some decision of Honorable Supreme Court in respect of determination of the income of the farmers